All right, I guess it's close enough. We'll call to order public meeting number 48 of the Massachusetts Gaming Commission on Wednesday, December 23rd. We're just going to run through another bunch of so-called key policy questions, starting out with question number 27, which was the work of Commissioner Cameron.
Mr. Chair, it is. And the question number 27 has to do with when should regulations regarding check cashing be issued and what should those regulations contain. Once again, the legislation was pretty specific. Addresses check cashing and credit issuance to patrons first. The section prohibits a gaming establishment from cashing a check unless in accordance with our regulations promulgated by the Commission. The Commission shall issue regulations prohibiting a gaming establishment from cashing a government-issued check. And these regulations should be written in consultation with the Department of Transitional Assistance, the Department of Labor and Workforce Development, the Department of Housing and Community Development, and/or applicable administering agency. Also, the law prohibits a junket from engaging in efforts to collect upon checks that have been returned by banks without full and final payment, and prohibits the junket from acting on behalf or under an arrangement with a gaming licensee or a gaming patron with regard to the redemption, consolidation, or substitution of the gaming patron's checks awaiting deposit. The law also prohibits gaming establishments from marketing or granting access to check cashing privileges to persons on any excluded persons list. In addition to the law, our strategic plan on pages 126 through 128 provide guidance, and pages 140 to 150 is a summary of money laundering and best practices for preventing it. So there's some specifics there also. Public comment on this issue. Sterling Suffolk addresses this in the same manner. They have many other questions, establishing internal controls. And the recommendation on this issue, obviously, you know, we'll have to first set up meetings, and I think we'll have to do this pretty quickly since we're going to start writing these regulations pretty soon. This will be part of our phase two. Right. In other words, this is not something we need for the application, phase 2 application, but we will need it shortly after for all, as we will with all of our operations in the casinos themselves. And I think having the meetings with these other stakeholders and listening to their ideas on check cashing is obviously something the law establishes, and we should do that. And I think in addition to that, the strategic plan lays out some best practices there. So I think this is an area in which we don't have to reinvent the wheel. We're going to look at those best practices as well as listen to the other stakeholders in the matter. And we just, the goal here is to prevent abusive practices by licensee and reduce the chance of money laundering. So we will keep those two things in mind in writing these regulations in consultation with our consultants.
I think that's thoughtfully done, as usual. The only thing that I would add is I remember that at our compulsive gambling conference, we heard some testimony from a gentleman who got in trouble in Massachusetts, and then he went someplace and they shut him off after he bounced a check, and he said that he wished that he had that. Wherever it was that he got in trouble.
I think it was he got in trouble in Connecticut, and they let him continue to write checks, and then he went to New York, and they wouldn't because of his record of bouncing.
Then he bounced.
So there are different standards.
Yeah, he bounced a single check, and that was a flag, and they cut him off. It seems to me we ought to think, in addition to money laundering, about prevention of compulsive gambling when we deal with this, and have the regs deal with that
Yeah,
as well.
prevent abusive practices by licensees. And I think we can, that can apply to the patron and what's in the best interest of the patron.
Yeah.
Which means very strict policies on check cashing.
But
Right.
Commissioner Q is right, it's sort of a different angle on it, and we might, there are probably people, maybe the consultants have expertise in this area, but there probably are people in the problem gambling area, you know, who might have insights to this that are a little different from the normal run-of-the-mill insights.
Maybe it would be a good idea when we're inviting all of these other folks to a meeting to talk about this issue, we invite
Yeah.
I think.
the council members.
I think that's a pretty good, great idea.
Yeah. It's really self-inflicted wounds
Mhm.
rather than sort of that we're trying to prevent there. So, but I
Yeah.
think that'd be great.
I'm adding it to the list, so when we have that meeting, we'll invite, we'll make sure we have that group up as well.
Number 28 is also Commissioner Cameron.
And question 28, when should regulations regarding approval of promotional gaming credits be issued, and what should those regulations contain? Just referring to the legislation, the commission shall establish procedures and standards for approving promotional gaming credits, provided, however, that no such credit shall be reported as a promotional gaming credit by an operator of the gaming establishment, unless the operator can establish that the credit was issued by the gaming establishment and received from a patron as a wager at a slot machine in the gaming establishment.
What does that mean?
Yeah,
Does that-
Yeah.
what does that mean? Does that mean you can't transfer from other casinos? You can't, or you can't use your frequent flyer miles, or?
I think what it may address is whether or not you can claim that as for
Mike?
Oh, sorry.
I think what it may address whether or not you can claim that for tax purposes, as, so that unless the credit is used, it's not a deduction for you. As
Oh, I see. This is a constraint on the operator.
On the operator.
Yes.
Right, not on the
Right.
recipient.
That's right,
Okay.
that's right.
So you can't
You
claim
can't
a
claim the
credit.
credit as an expense unless
Got it.
it's actually wagered.
Right. Right.
But, I'm sorry, guy, but
Yeah.
the distinction here for the slot machine, does that differentiate, let's say, a table game?
It would, although typically the credits are issued for slot machines. I mean, I don't know of a promotional credit, there's match play, I suppose, that is also used at table games. But
games.
this one seems to just address slot machines. I don't know why it makes that distinction.
Okay.
Okay, so Sterling Suffolk responded to this question, and again, just mentions all of these questions, then they pertain to gaming establishments' internal controls. They discuss the same procedure for question 24. Mohegan Sun encourages the commission to consider regulations on promotional gaming credits in the early Phase 2 regulation process, but also keep those regulations flexible to adapt to future needs when casinos open in the Commonwealth. Both New York and Connecticut have recognized that a certain amount of promotional free play is pro-competitive and enhances gaming revenues and benefits to the states, but at some point, free play, if let unregulated, can diminish revenues. And this was very similar to a question we had yesterday. The same comments, and our consultants talked about that as well. Connecticut free play redeemed at 2 tribal casinos in excess of 11% of the net slot win for each month is subject to a contribution payment to the state at a rate of 25% at a net slot win. Okay.
So I don't quite follow that either. What is?
Yeah, that's the comment from Mohegan.
Well, isn't that part of the point that was just made earlier, that you cannot claim it as a credit if you're the operator? So,
But why would
But it
an
says redeemed.
why would, sorry, why would an operator, don't the revenue in the state, don't the operator in the state have the same interest in maximizing gross gaming revenue? So why would we need to regulate them from giving away too much free stuff? Go ahead, Michael.
The way I interpret that last statement, and it's not uncommon for states to limit the amount of free play. And in some states, as I recall which ones, they actually tax free play as if it was wagered. The way I interpret that last statement is that there's a cap in Connecticut of 11%. You can't go above 11%. If it's over 11%, then the free play is taxed. It's not a tax in Connecticut. It's revenue sharing at 25%.
Because of the compact.
Exactly.
Yeah.
But what's the business incentive for somebody to give away so much free play that they diminish their economic viability?
Something's wrong in that situation, because it defies business logic. These are poor business decisions that clearly are being made. They're giving away too much money and not getting sufficient return.
So the regulation to limit the amount of free play would be a regulation to prevent the business entity from harming itself.
Kevin, did you write this?
Yeah.
Can you explain it? I mean, what are we missing? Come on up. Michael, stay there if you've got something to say, but I just think, we happen to have the maestro here who wrote
Sure.
this, so.
My understanding is that in other jurisdictions, what we've seen is that the free play has become an entity that casinos use to compete with each other. And sometimes at these casinos, what we've seen is that the free play sort of overtakes, becomes such a hot topic or such a hot area of competition among casinos that you see them giving so much away. And what we've seen in some states is what the response to that has been is that they're going to limit it. And you're exactly right, above a certain percent, they're going to treat just like they treat casino revenues. And so they're going to call it a tax, or you can call it whatever it is. And so what some states we've seen, and I think our comments encourage you to do, is at least think about whether you want to put some sort of limit on free play, because, you know, the free play amounts, if you don't put some sort of limit on it, what you see is that it becomes a really hot, could become a hot competition, and potentially the state could lose revenues at the end, because you're not on
So
this free play.
it is, as Commissioner McHugh said, we're looking for a reg to protect the industry from itself, sort of.
Well, I think that's one could look at it that way. I wonder if you're looking for a reg that in essence potentially protects your revenues, because.
But in theory, you know, they're competing presumably because they're trying to protect and drive up their own revenues. So they have the same objective.
Well, but
They think that giving away free means you're going to keep more people, which means you're going to get more money. They're not giving away free play because they think it's going to reduce their revenue.
Right. Well, obviously, this free play also gets people in the casino door and
Yeah.
means that they spend money on other
Other
things
things,
other than
yeah.
casinos that you don't necessarily tax at, you don't necessarily tax
share.
at the same share. And so that's been what we've seen in some states. It's been a way to get people in the door, and they don't necessarily therefore then spend their money at the table. They spend it in different ways. And I think our comment wants you to at least consider that you may, and I think too, you may want to look at, this was a subject of at least some discussion among the legislature as part of the crafting of the bill, and you may want to go back and at least take a look at what, I think you read what the actual legislation had, but there was some debate about this at the legislative level, and I think our comment says to you may want to at least consider whether you want to put a cap on this and sort of some of the revenue implications for the state as part of this.
there's also, companies at different times make short-term decisions or longer-term decisions, and I wouldn't characterize it as protecting it from itself, but the incentives, depending on their finances, let's say, may change at different times. They may be being too aggressive, let's say, for short-term revenues, given a lot of things going on elsewhere, outside of Massachusetts, let's say, in their corporate structure. So from Massachusetts' standpoint, in addition to what Kevin says, this would be a way to protect the interests of the Commonwealth, which are long-term by its very nature.
But on the other hand, I mean, I'm not disagreeing with that. On the other hand, it seems to me that the use of free play, particularly in a region like New England, where the travel distances are relatively short, and could be used as an incentive to get people away from to draw people into the state who otherwise would be going someplace else. I mean, you could have a free play war between a Massachusetts casino and an out-of-state casino that would draw people in, and then once in, use the other devices that keep people in to keep them coming back. I mean, that's a theoretical possibility at least, right?
And for that instance, I would perhaps make the argument that if we were to cap it at 12%, let's say, 1% higher than Connecticut, that could incentivize somebody to come back to, anyway, I don't want to split hairs, but you know, the point is that I do believe that some sort of cap would be relevant.
Why is it in the interest of Mohegan Sun to make this recommendation?
I mean, I think my sense on what Mohegan Sun was worried, and this came out a little bit in the legislative debate, is that I think you've characterized it a couple of times as the industry sort of needing you to regulate to protect it from itself. And I think what Mohegan Sun's point of view on this is some sort of regulation in this area may make sense, because it not only protects the casinos, it tells the casinos you can give this away, but it protects your the state's revenues, right? And one of the things Mohegan Sun wants to make sure is that when it gets its license, that the state thinks it's getting its fair investment out of Mohegan Sun. And I think what they've seen in other jurisdictions is that if there is not some sort of cap on Unlimited Way, there becomes a big competition on Unlimited Way, which hurts not only the casinos, but it hurts the state's revenues.
Okay.
I don't want to push that farther, but just why couldn't it, if you turn it around, I understand the state revenue piece, but why can't it also be viewed as a pricing floor, sort of an artificial pricing floor that works against market forces that ordinarily are going to lead to the highest yield because these people are smart operators?
Or the best consumer deal, on the other hand, driving prices down, in effect.
Yeah, which is maybe antithetical to the interests that the state has.
In one sense, but on the other sense, right. Yeah.
Right.
Just one other point is that putting a floor and putting a taxing free play at a certain level does not necessarily eliminate free play. There are states where it is taxed and operators still pursue it, but they price that into their decisions. And I also note that we could easily and relatively quickly summarize how all states are doing this and handling this and get that to you.
That'd be great. I interrupted you, Commissioner, when you didn't get an answer to your question.
No, I don't know. Maybe you
I was pretty happy that you saved me, Chairman.
Give me time to think.
My sense on this is, you know, this is a debate that the commission has.
Right.
It goes through nearly everything the commission thinks about, which is, you know, do we need to regulate in this area, or do we want to leave it up to the casinos to allow market forces to decide? Right. My Mohegan sense on this is that because this affects not only casino competition, but really affects the revenues that the Commonwealth is bringing in, that is probably an area that you want to think a little bit more about regulation than allowing to leave this to market forces. And it's a good question, and one that you debate and think about every day, I think. So I will note that I think our comments are maybe a grand total of a paragraph on this issue, and we would be happy to supplement that as well and provide some further thoughts on that. I don't think they're as in depth as we can make those much more comprehensive, and we will.
We would welcome those comments.
Okay.
Both of those, of your offer, Michael, also,
Right.
and Kevin's as
Very
well,
helpful.
great, because it's a fascinating intellectual.
Right, it is.
Well,
Michael, don't go away. Go.
So
If
just
we-
to finish up on,
go
oh,
ahead.
I'm sorry, go ahead.
No,
You're
I'm
in the middle
thinking
of-
if we did set some type of level, or would we be constantly coming back because now all of a sudden the neighboring state is loosening up their restrictions, and we're constantly having those back and forth about raising the limit or lowering the limit?
If, in other words, if I understand your question, do states sort of get into pricing wars with each other using this? I'm not aware of that. It's certainly a possibility.
But to the chairman's point, we're in closer proximity here than maybe
It
other jurisdictions.
highly unlikely, particularly since in Connecticut's case, that it would require presumably renegotiating the compact in order for that to happen. Highly unlikely, but it's certainly a possibility.
Is there, there's an overarching goal as part of the strategic plan that you've also mentioned, in general, starting from a regulatory standpoint, starting tight, if you will, and then if conditions change over time,
Yes.
loosening up
Yes.
certain pieces of regulations. Is this one that, you would see as potentially starting at some level and then loosening up based on market conditions and some maturity in the industry here in Massachusetts?
Good question. As you know, we fully endorse the concept of starting strict and then as experience dictates,
Yeah.
loosening or reforming regulations. I'm not sure this would fall under that. I think the experience will dictate whether or not, at whatever level you decide to set it at, experience can dictate whether or not you've set it at the correct level, and you can certainly adjust based on whether or not such adjustments will presumably would increase overall gross revenue, which would then be taxed. But it's, I wouldn't call it overregulation, but I think it's certainly something that as time goes on can be adjusted, and my recollection is that certain states have done precisely that.
Is there enough, you're going to give us a comparison of what other states have done, but is there also empirical information to say that when they set it at X, revenue projections went to a certain amount? I mean, is there enough historical data to show when some of these amounts were adjusted, what that did? Kevin's point, we need to be mindful of this, assessing the impact to the revenue of the Commonwealth.
That's a tough one. I know we have done hypothetical scenarios, that we've done hypothetical scenarios where we've run through precisely that if free play works as expected at a certain level and not taxed, it can generate X amount of revenue. I'm not sure if we can identify in any state how it's translated into action, if they've adjusted it, and what happened as a result, where they can tie in a clear cause and effect. But hypothetically, it's very easy to do.
Okay.
Thank you.
Well, that was more than you were expecting.
Well, no, it's interesting, and there's one piece that I'd like Kevin to speak to also, because I think our consultants have, it's the intention that this matter would be handled phase two, correct?
Correct.
So it's not something we need to address before that phase two application. But I see that Mohegan Sun does recommend considering it early on. Is there a reason for that?
I don't, Commissioner, I think our sense is that this is certainly falls below the licensure questions that you need to resolve, and this is one that would fall below that and can be done after that. I think, on the other hand, we do, it does affect how the various applicants are thinking about this and how they're going to make their decisions, and so we would encourage that, but I think the phase two, as the commission has now developed the term yesterday, I think is going to be appropriate for Mohegan Sun and the other applicants.
Okay, thank you very much. And as you can see, I left the generic, rather the recommendation pretty generic, which is, it will be done in the second half of phase two, and which is soon, by the way. That's just a couple of months here. And we should approve a minimum amount of promotional gaming credit in order to enhance the competitive environment, but not so much as to destroy the viability of the industry. So it's pretty generic, so it gives us room to really think about, and we look forward to those two documents to help us decide if it should be a clear percentage or not.
Is promotional gaming credit synonymous with free slot play? Is that what that, does that what promotional gaming credits means?
Any kind of
Yeah, it's a,
free play.
Basically, I mean.
yeah, it's a subset, the slot play will be a subset of promotional gaming credits. So all promotional.
Be other.
All slot play, all slot credits are promotional gaming credits, but not all promotional gaming
Okay.
credits are.
But
slot.
most of them are, it sounds from what you said, is basically in the slots that various kinds of promotional, so you mentioned.
For the
some
most part,
places.
there's what's called match play
Yeah.
on table games, where if you place a certain amount, you're given the same amount to play in addition to that, so that's usually at table games.
Yeah, okay,
But that would also be a promotional gaming credit.
okay.
Do you see casino operators using this more frequently at the opening of a facility to draw people in? Or does it remain pretty consistent across?
It's pretty consistent. For the most part, the operators that have expressed an interest in coming to Massachusetts are experienced operators who will bring with them marketing plans that they have used successfully in the past in other jurisdictions, which would include these kinds of credit play and promotional offers from the outset.
Okay.
Thank you. Question 29?
Yep.
When should regulations regarding excluded persons be issued, and what should those regulations contain? Our law does speak to this, requires the commission to issue regulations creating an excluded persons list and a list of self-excluded persons, and it provides some of the factors. The section also deals with punishment, adjudicatory hearings, privacy of the list, and interstate compacts. The only public comment is the same comment from Sterling that this matter should be developed with our internal controls. I think there is no, we're talking about, again, phase 2 here, phase 2 of phase 2. It isn't, it's something that we needed to have in place before operations begin. And I talked about this with all of the consultants, and we talked about other jurisdictions. Some of them have a 5-year, a 1-year. It was pretty much the consensus of our consultants that we talk about a 3-year period. And with the option to exclude persons for a longer period of time. This may also be a question we invite the compulsive gaming folks in to just hear what they have to say on this matter. Steve, you have.
I wanted to draw the distinction, as you began to do, between the involuntary exclusion list and the self-exclusion list. Generally, the involuntary exclusion list, you're placed on it, and then the jurisdiction may have mechanisms for removal from that list. But without that being in place, they are generally lifetime placement on the exclusion list. The disparity with respect to the duration is, it pertains to the voluntary self-exclusion list. Some jurisdictions have imposed a lifetime self-exclusion list, so you place yourself on that list and there's no, it's irrevocable and you cannot get off. Missouri has that, for example. New Jersey imposed and I participated in the drafting of the regulations in New Jersey, a 1-year, 5-year, or lifetime, and it's at the option of.
This is on the self-exclusion.
Self-exclusion,
Yeah.
right, the voluntary, again, just to emphasize the point, the involuntary exclusion list, you're placed on that list, and unless you make an affirmative showing to be removed from that list, you are on that list for a lifetime. In fact, some people are not removed from the exclusion list, this happened in New Jersey, until after they have died. And then there'll be a family member who will petition to get someone off the exclusion list, and that actually did happen in New Jersey.
Was it granted?
Yes, it was granted unanimously, I might add.
It's a 4-1.
One of the easier judgment calls.
Denied, they couldn't have
One of
been
the easier
reversed.
judgment calls the commission had to make. But with respect to the voluntary self-exclusion list, New Jersey had a 1-year, a 5-year, and a lifetime. And if after 1 year, there were procedures, if you placed yourself on the 1-year list, there were procedures for how you removed yourself. If you didn't follow those procedures, you remained on the list. In other words, you did not come off the list automatically at the end of 1 year or 5 years. You had to affirmatively establish that you were no longer a problem gambler.
So does this Commissioner Cameron, was this referring to both, the
Well,
self-exclusion?
we need to have both,
We
as
need to
per the
have
law.
both,
We
right.
do. We need to have both. This is referring to the self-exclusion. Obviously, the.
This is the self-exclusion.
Yes.
Now, this question, I think, will pertain to both, but then there's a dichotomy, and that's what drew my attention when I saw the recommendation, that the recommendation focuses on the voluntary self-exclusion list and not the involuntary exclusion list. And there's a number of issues that come up in the next couple of policy issues that deal with exclusion, that you need to focus on that dichotomy again. It has to do with sharing of information. Okay, the
Seems to me like
self-exclusion
there's
list is a confidential list that the regulatory agency will maintain with strictest of confidence. The information on that list is shared with the casino operators who are sworn to maintain the secrecy of that list. Because they are under an obligation, affirmative obligation, not to allow someone on the self-exclusion list to patronize their casino and issue credit, comps, or whatnot, okay? They're supposed to maintain that list. But there is a confidentiality aspect to it, as opposed to the involuntary exclusion list, which is a public document
Right.
that may be shared.
Right, they seem to me like two very, very different.
They are
kinds of
totally
lists.
different
Right,
paths. They are not on parallel
Right.
regulatory paths at all.
right. And so the recommendation goes to the involuntary exclusion
Correct.
list, not the self-exclusion list.
No,
No, just the opposite. Just the opposite. Yeah, I emphasize again, the involuntary list is a lifetime. You are placed on that, and then your regulations, and we'll work through this, will have mechanisms for seeking removal from that list. Most applications to be removed from the list are frankly denied.
This is like for
I
somebody.
only know of one
So,
instance
a
where it was
known-
granted in New Jersey, apart from the person who died. I mean, to
This
be
would be like
removed.
for a known gambling cheat, for example.
Members of organized crime,
Yeah, okay.
notorious criminals, people who generally are perceived to have nefarious backgrounds that would create an appearance of impropriety if they entered the gaming establishment.
Right, okay. Okay.
Whereas the self-exclusion list is something that came into play in the 1990s. In the early days of New Jersey, there was no such thing, and there wasn't in Nevada. And with the more publicity tended to problem gambling area, there became a cry, so to speak, for a self-exclusion list that would work hand in hand with problem gambling programs that the different operators had already implemented.
Right, okay. So
Now, the
you're,
recommendation here is for a 3-year period, but that could be discussed.
self-exclusion. That-
For the self-exclusion, that could be discussed further.
I would say, yeah.
Well, yeah, I mean, we talked at length about this, frankly, and that was a consensus of, 1 year was not enough, and 5 years was considered too much.
Right.
So 3 years was.
Do you know how? it
See,
works in
the threshold issue that I think you need to address is whether you want it to be a lifetime and nothing else. And if you can resolve that in the negative, that you don't want it to be a lifetime, you want the person to be, maybe re-examine the issue after, whether it's 3 years, 5 years, 1 year, 10 years, whatever. Because the person based on the lifetime, our experience was then it could be 2 or 3 years later, they're seeking to get off, and they can't. And there was litigation. I wasn't properly informed of what the ramifications were. You may place yourself on the self-exclusion list in one jurisdiction, but you think you can gamble in another. That may not always be the case, because the casino, particularly Caesars, someone is on the self-exclusion list, they put themselves on the self-exclusion list in New Jersey, they show up in Nevada, and Caesars casinos won't allow them in. So then they'll argue that I wasn't told that.
And why wouldn't a lifetime-only self-exclusion list be a disincentive to putting yourself on there, too? Is there any data to show that more people are likely to take advantage of it if they have the 1, 5, lifetime
I
choice?
don't know if there is any such data. When people make the determination to put themselves on the self-exclusion list, at that point in time, they're positive it's the right decision. They may have gambled that night, spent all night, lost everything. That day, the next day, they want to put themselves on the self-exclusion list. We had a waiting period so that people actually did this, because it has to be, to work, it has to be a completely voluntary thing. And we had people who were actually under duress. They would, the stereotype thing would be the husband shows up, the wife's in the other room, and after 2 or 3 questions, you could tell that the husband is only there because the wife drove him to the commission office to sign up, and left to his own devices, he would not. Well, that's not voluntary. So you want, it has to be a voluntary thing, because you are taking away someone's right of free expression, for lack of a better term. It's not a criminal act to gamble. So you want this to be a completely voluntary process. But there are, the example that I had just given, 48 hours later, that person may have decided, I don't want to be placed on the self-exclusion list. It's a life-changing decision for people. And don't kid yourself, the people will frequent the courts and indicate, and you really do, and we will do this. We will have very detailed policies and procedures to kind of, eliminate the possibility of successful appeals. People will frequently argue that they were not adequately informed. They did not have the proper informed consent when they placed themselves on the self-exclusion list. They'll make stories. They'll say, I thought that I could get off at any time.
Wouldn't the decision for this commission and others about the point you make, trying to decide whether there should be a lifetime exclusion list or not at all, be one question fundamentally of belief in rehabilitation? I mean, aside from the notifications and the proper disclosures and et cetera.
It's a difficult area, because when you speak with experts that are in the problem gambling area, from that arena, they will tell you that you are a problem gambler, you will always be a problem gambler, and there is no so-called rehabilitation as there would be from criminal activity. Others will say, from the regulatory perspective that I would deal with, is that there are necessarily different levels of problem gambling, and some people may think they're a problem gambler, and maybe they're not to the extent that someone else is. Some people, I guess one of the things is, can you get up and walk away from the table at a particular time? Or do you wait until you've lost everything and then you're forced to get up from the table? And credit is denied.
You're not going to put yourself on the list if you're not pretty clear. You got to.
No, that's not always true. There were people, again, they might have had one bad experience, and they blew their rent check. Okay. They had gambled for the last 5 years, nothing out of the ordinary, what was ever to get away, but that one particular day, for whatever reason, they couldn't remove themselves from the table, and they lost more than they thought. Well, they just had a bad streak of luck, and it was not so much a matter of getting up and out, but they lost more than they'd gone into the casino thinking they would spend $200, and they lost $1,000, which they could not afford to lose.
Yeah. From a public policy standpoint, I don't see the problem with if somebody comes in after one bad night and puts himself on a list, keeping him on the list. But I understand they might change their mind, but from a
No, again, that is a public policy issue. What you want to have is a period of a length of time, so you don't have a revolving door. Certainly you don't want to have a system where someone places themselves on a self-exclusion list and they can remove themselves immediately, and then they're back 2 months later, and it becomes an administrative nightmare. You want to have a duration of a significant length. That's just why the minimum is generally 1 year or 3 years, and 5 we talked about. Again, just to emphasize the point, and it's a policy issue, which is going to need considerable discussion of whether you want to limit it to a lifetime. The consultants don't believe that you should have only a lifetime. You could have a lifetime as an option, but we also believe that there should be a shorter duration period.
And that's what we talked about in, the ability to exclude for a longer period of time under certain circumstances.
But this is why I thought this was for the other list, because this is, I mean, you don't need an option to exclude if it's a self-exclusion list. You put yourself on it.
No, no, no. In other words, we would, if our policy decision is to have a 3-year.
Right.
But if there were certain individuals who, their circumstances were so extreme that we had the ability to exclude for a longer period of time. And those are the discussions we had. Do you know what I'm saying?
Yeah.
In other words, don't have the lifetime ban,
Right.
but have the ability to exclude in certain circumstances a longer period of time. So that's, you
Well,
know,
I
there's
think-
no, as far as I know, and we discussed this one at length, you know, there's not a lot of research on, is 1 year better than 3 years, better than 5 years, better, you know, there just isn't. So jurisdictions are all over the board on this one, and what we thought was reasonable was the 3-year, and with the ability to exclude for a longer period of time.
Do you happen to know what Iowa does?
I don't.
Anybody?
No.
No, off the top of my head.
They have a tremendously successful list, meaning a lot of people on it, but, well, it'd be interesting to talk more to the problem gambling people and get their views on this too.
Agreed,
Yeah, I would like to hear more from them, and insofar as the duress thing is concerned, I understand that it's gotta be voluntary, but, you know, people make choices all the time, and the couple that comes, and one person is brought to the place by the other partner, may be facing a choice, sign up for that or I'm gone, and that's a reasonable choice to make. I don't know why we should wanna discourage that, so, but I'm not wedded to that either. I mean, I just think we need to discuss further.
Yeah, I just raised that as something that the commission and the consultants together, we're going to need to think through.
Yeah.
The different variables, and we could draw on our experiences, and I sat through a number of these sessions with someone who was attempting to place themselves on the self-exclusion list. Most of the time, they were admitted to the self-exclusion list,
Right.
but we were trained, and we trained the others later, that it was not necessarily going to be 100% someone shows up at the door that they're placed on the list. We wanted to make sure it was voluntary. It's somewhat akin to a voluntary confession. I mean, you want to make sure that the person is not acting under the duress. Now, the fact that someone is driven by their spouse does not negate the possibility of a voluntary placement on the list. I don't want you to misunderstand what I was saying.
But I'm sort of sympathizing with Judge McHugh that I'm not sure I agree with that, you know, but. I
Right,
also-
it could
I
be,
also-
I'm saying that it could still be a voluntary, but what.
Or maybe it's not voluntary, but there's no reason why it shouldn't happen, you know, if you.
Oh, well, see, that's where I would disagree. I think the notion of the self-exclusion list has been put into place, and this has been, you know, historically, is that it is a voluntary act. And you need to establish that it's a voluntary act. Whatever procedures you want to have in place that establishes that it's voluntary.
Well, no, I understand that, and it's one thing if you need to establish that voluntariness in a therapeutic sense, because it's not gonna work insofar as the self-exclusioner is concerned. He or she is just gonna find another way to gamble. That's one thing, but if it's voluntary in the sense that, from the gaming establishment's position, you don't wanna take away a customer and a source of revenue unless the customer really wants you to do it. That sets up a different set of considerations, it seems to me. So this discussion with the problem gambling folks, I think, would be a really helpful discussion in working through and then overlaying your experience in that discussion before we make a final decision.
Yeah, now, the other thing that's interesting is that the Massachusetts statute requires this, as does New Jersey, that the regulations in New Jersey, it's not the statute too. The person has to acknowledge that he or she is a problem gambler. And absent that, it's not, the statute says that you cannot be placed on the self-exclusion list. Now, people have been known to state that they are problem gamblers simply to get on the list. And then they'll have signed it and they'll be walking out and say, you know, I'm not a problem gambler, but they're telling you the truth then or now, you don't know. But that is a requirement that someone actually acknowledge that they are a problem.
That's in our legislation,
Yes,
you saying?
it is. It's in 45F. 45F. It says they have to file a statement with the commission acknowledging that the person is a problem gambler. And that's standard in the industry.
I came up here when you were talking about Iowa. I don't know if the time has passed. I was just going to say that Iowa will take a look further into the Iowa situation because they have traditionally been a jurisdiction that has been very careful about the issue of not only problem gambling, but if you can call it over gambling. Iowa initially, and for a long time, I think until recently, had loss limits, so that people who wagered in Iowa casinos were only allowed to lose a certain amount of money, and then they had to leave. So we'll take a closer look at it.
Yeah, we've heard him, the guy who runs that program spoke at our forum, and I also heard him in Vegas, and he's obviously a really knowledgeable. I mean, it sounds like they have a really effective list, but I'd love to know more about it. 29 is down.
Okay, 30?
Go for it.
When should regulations regarding the provision of complimentary services, gifts, cash, or other items of value be issued, and what should those regulations contain? Again, this is, phase two. It's got to be done before we open the doors. And the law speaks to it. 23K speaks to governing complimentary services to patrons and provides that no gaming licensee shall offer to provide any complimentary services, gifts, cash, or other items of value to any person unless the complimentary item consists of a room, food, beverage, transportation, or entertainment expenses provided directly to the patron and the patron's guests by the gaming licensee, or indirectly to the patron and the patron's guests on behalf of a third party, or the complimentary item consists of coins, tokens, cash, or other complimentary items or services provided through a complimentary distribution program, which shall be filed and approved by the commission upon the implementation of the program or maintained under regulation. The only comment was, again, Sterling, Suffolk, and, have this covered in the internal controls. I think this is very specific, and certainly will adhere to this, and I think the important piece here in discussing with the consultants is that whatever complimentary gifts and services, according to the law, but that the programs, we keep strict record keeping of the approved programs and the distribution programs, so that we really do make sure we're tracking these approved programs. Obviously, they have to abide by the law, and then we need to make sure we do a good job keeping track of those approved programs. If I can ask, I know we talked about this, but is this one of those questions that we allow them to say to us, this is the program, it adheres to the law, and then we look at it and approve it, rather than us dictate the exact program?
Yeah, I believe the consultants would recommend that this be included among the list of areas that can be given to the casinos with more discretion, that this would be a program could be submitted to the commission for approval, rather than the commission dictating to every casino what their programs have to be in detail.
Okay, and we just need to have a way to make sure that they are adhering to those.
Yeah, that would be a function of the regular audit and observation of the casino operation.
Is that what this is getting at? It's oddly worded. It looks to me like what it means to say is, a gaming licensee cannot provide any complimentary anything unless any complimentary anything is approved by the commission. It really says you can give anything it wants to as long as it's approved by the commission.
Was it not pre-approved? I think what we were talking about was what nature of approval are we talking about here? And not, certainly, any form of complimentary can be permitted. There are no prohibitions here that I recall in the statute, for example, for cash complimentaries, where some jurisdictions prohibit that.
It can be any complimentary item or service that is in a program that the commission approves. It's just a funny way to get that. It could have said, any complimentary program and good or service given complimentarily has to be approved by the commission. Instead, it goes through this elaborate thing about, and I just kind of wondered what this was getting at, because I think what it says is, you can give away anything you want to, as long as it's a part of a program approved by the commission.
I think that's what it says, too.
Right, okay. I just wonder why it didn't say that, you know, if there was something else that they were trying to get at here.
So,
Do you agree with that, Commissioner McHugh? Is that's in effect what it says, right?
I thought that I thought this was designed to exclude, and that's why I have a question, exclude gaming, gaming credits and other forms of non-amenity gifts and complimentary things, and that they only could be given directly to the patron and not to a third party, say, and that they had to be given in accordance with some program that we approved. So excluding gaming-related gifts, complimentary gaming credits and the like, which are regulated under another section or not at all, and then given directly to the patron or the patron's guests and not to third parties. And
Or on behalf of a third party.
I mean, for example, you could theoretically, I suppose, have complimentary things given to a junket operator or to a travel agent or to somebody else who was steering people to the casino, right?
They wouldn't be complimentary, but essentially they'd be fees. I mean, you pay the junket operators typically to bring you customers.
Yeah, I see. But
Third parties, they may mean, and I don't know why this would necessarily be prohibited. I wouldn't read it to prohibit it, but if you're giving a customer's wife something, rather than the customer themselves, that should certainly be permitted.
Patron or the patron's guests.
It would include the wife.
Right.
So
It does,
I mean, I agree.
Well, it may not necessarily be the wife, right?
I don't see why I don't know that this really matters, but I don't see how this precludes giving credits.
To third parties?
Oh, to third parties, yes.
Right.
It's limited to, you can only give to a patron, to the guests, or to the patron or guests on behalf of a third party. But you can give anything to those people.
Well, no, it says,
If we approve it.
unless the complimentary item consists of a room, food, beverage, transportation, or entertainment expenses approved by the commission.
Or other complimentary items or services provided through a complimentary distribution program filed and approved by the commission.
Yeah, no, I see what you're.
That's the clause that I
see how
think,
you-
that's the
yeah,
clause that
yeah,
seems to undo
right.
the one up above,
Right,
which is why
right,
it's
right,
puzzling.
right.
But anyway,
Right.
just,
What we were addressing was the extent to which the commission needs to approve these programs. And our recommendation would be that you not necessarily need to get into the nuts and bolts of every program to say a particular gambler has to have a standard, to calculate on what their standard loss would be at a casino, that those standards need to be X number of dollars for you to get a room, they have to be Y number of dollars for you to get a meal, they have to be, that you not necessarily have to get into that kind of detail on everyone's program, as long as they have a program that gauges the amount of their complementary on the amount of money wagered, so that they're giving away items in some reasonable manner.
This is really,
Well,
this
now
is really weird.
Now I'm going back to what the chairman said, and it seems that you can give the room, food, beverage, or transportation or entertainment without commission
Without
approval.
approval.
And
Or-
then all this other stuff, you can give anything
Or
with
anything
approval.
else with approval, right. I
Yeah,
think-
yeah, I think that's, yeah,
So
Yeah.
that would be,
Right, I still don't know exactly what it, if coins, tokens, cash, no, I don't know, that's weird. So there's a bunch of stuff they can give willy-nilly, but anything else outside the, the food, room, beverage, transportation, and entertainment has to be a part of the complementary distribution plan filed and approved by us.
the coins, tokens, cash would be under the credit, gaming credit
Yeah,
areas
maybe
that we talked about previously.
and so maybe that ties back into the, you don't want operators to self-immolate. Well, you don't want operators to be giving out
Right.
so much
Right.
that they're gonna do harm to their,
Right.
themselves, or strip the Commonwealth of revenue that they otherwise could be collecting.
Right. This would be an interesting one to talk to the drafters, just out of
Right.
curiosity to see what they
Right.
were getting at.
Right.
All right, we tortured that one. Or he tortured us, I guess.
Yeah.
Little bit
More,
of both.
more work to be done, right? Because we'd want to really
I mean, I think-
understand what
I think we
the
need-
plans are like.
Well, I think we need to understand what the legislature was really trying to do here. I don't really understand exactly, hello?
So, I think.
Maybe that was the
I think you clearly articulated, and I think that's the intent, that we're not gonna get involved, or they don't see any need for us to get involved with room,
Or
food,
regular
beverage,
stuff, right.
transportation, but we absolutely should
Right.
approve
Anything beyond.
the coins, the
things.
tokens, which does get back to how much free play,
Right.
right?
Yeah, okay,
Okay,
good one.
question 47, and this.
Oh, my God, it's still Commissioner Cameron.
I know. Should the commission adopt the self-exclusion list in effects in other jurisdictions? The law tells us that the commission shall pursue an interstate compact for the purposes of sharing information regarding the excluded persons list. There are a bunch of comments here on this one. Sterling, pretty specific. They're not aware of any jurisdictions that shares its self-exclusion list outside of its state. Self-exclusion exclusion lists are extremely confidential, highly protected due to the privacy concerns, while some jurisdictions have in the past discussed sharing self-exclusion lists. SSR is unaware of any jurisdiction that has done so, implications of sharing self-exclusion lists across jurisdictions, that would need to be addressed. And they list a bunch of issues: the responsibility for the combined list, updating and maintaining information on exclusions and reinstatements across jurisdictions, addressing potential differences in reported information, assessing whether commissions have statutory authority to exclude a patron based upon self-exclusion requests made to the commission outside their jurisdiction. Provided example of treatment of self-exclusion lists in other jurisdictions in a Q&A from the Missouri Commission site. SSR believes that the best regulations allows the licensees to extend their self-exclusion lists across all of their brands, including locations outside the original state. Caesars currently employs this policy across all of its brands. It is worth noting that some jurisdictions will not recognize an exclusion because the request initiated with a commission outside of the jurisdiction. Shefsky, we believe a robust self-exclusion policy is in the best interest of the Commonwealth and each host community. self-exclusion lists similar to those used in other jurisdictions should be utilized, just a generic answer. And in, again, discussing this, we should certainly share the information regarding our excluded persons lists as the legislation requires, but the list of self-excluded persons is confidential. There are many privacy concerns, as we just pointed out, or Suffolk pointed out to us, with sharing the information of individuals, the self-identity, and as requested exclusion from gaming facilities. We share, we should allow those individuals to place themselves on self-exclusion lists in other states if they so desire, but not require it. Also, many casinos use the self-exclusion list from one state to exclude those same individuals in their facilities. Caesar's just made that point. And while this is a good practice, it should not be mandated, is the recommendation. Steve, you wanted to speak to this?
Yes, I wanted to make a couple of points. Section 45K speaks of an interstate compact, and although it does not expressly state so, it may be interpreted that the intent of that was to pertain only on the limited basis to the involuntary exclusion list, where there would be a general sharing of information amongst regulatory agencies. On the contrary, the self-exclusion lists have been maintained state by state on a confidential basis, and there is no sharing of that information. The only sharing is from the licensees if a particular jurisdiction allows for it. The licensee may, in New Jersey, for example, Caesars shares that information with Caesars properties elsewhere.
Yeah. So I think that that's correct, because when we talk about the self-exclusion list and the way the law talks about excluded persons, they are the two different things we just discussed earlier.
Right.
And that's the information to be shared, is the excluded persons list, and certainly not the, which is the recommendation, not to share information on the
Right, and we
self-exclusion list.
And right, and we agree with that. Well, one point and another point I've neglected to mention before, and I think it's very important. It pertains to both the involuntary exclusion list and the self-exclusion list. The legislation specifically indicates that when you're placed on either one of those lists, you are excluded from the gaming establishment. It's not limited to the gaming area. It's the entire gaming establishment, which is defined very broadly in the statute to include non-gaming amenities, such as the hotel and restaurants. So if someone wants to self-exclude themselves from gaming activity, they need to be apprised that that will also prohibit them from attending a concert or staying at the hotel or eating in one of the restaurants. It's very broad when you're placed on the exclusion list, whether it's involuntary or voluntary.
Isn't it depending on how you draft the list? Why do you, doesn't have to be that way, does it?
Well, the definition of gaming establishment is written in the broadest
Oh, I see.
senses, and if it's interpreted in that broad fashion, now there is a possibility that it could be narrowly construed, but I don't think that's the favorable interpretation.
That's the way it is in other states, too.
Yes, right,
Premises.
it's the entire premises. The notion being that you don't want to tempt the person who's on the self-exclusion list, and the person who's on the involuntary list, you don't want them anywhere near the facility. So that is the intent.
But could we just test, as a default, it seems to me this recommendation is absolutely right, and because it is full of private information. But why, this, New England, again, getting back to the notion that this is a small area, you know, it's an hour drive from Boston to Providence or someplace. Why couldn't the self-exclusion list, application, in addition to giving the applicant a choice of 1, 5, or lifetime exclusion, if that's the way we go, why couldn't it also give them a choice of allowing the self-exclusion to be shared with other states? So that if they really were, and again, this would have to be voluntary, we have to, but if it is voluntary, why couldn't somebody make a decision that I want this list to be shared nationwide, I want to be excluded from every place? And then have some kind of a program where other states could honor that that list.
Well, it's something to examine, but heretofore, it has not been done in any jurisdiction.
I understand that.
So it would be something to think about, and certainly.
Well, we're,
I mean, if we talk to the compulsive gaming folks, it's one thing if you're in the middle of Kansas, and it'll take you 2 days to get to the next gambling place. But if you're here and the next gambling place is an hour away, that may pose a different set of circumstances that warrants giving people different choices.
But wouldn't it be incumbent upon that person to let them know in Rhode Island, I want to be on your list too? Connecticut, I want to be on your list too?
But why put
Make
a
it hard.
barrier in the path of a person who really wants to do that? If they want to do it. I mean, it'd have to be voluntary, but check this off and we'll share it with others if that would be helpful.
You recognize, there are people that have placed themselves on the self-exclusion list in one jurisdiction and then free to gamble in another jurisdiction.
No, I understand that. I understand.
I think this goes back to your point of therapeutic, because what I remember, one of the points I remember from our forum on compulsive gambling was that what seemingly was something onerous. In some jurisdictions, you have to walk through the casino floor into an office to place yourself in self-exclusion lists.
Right.
Is interpreted by some, at least, as because it's an active act, and because this is a voluntary act in nature, that in and of itself starts this therapeutic aspect of confronting your problem, if you will, by being proactive. But I agree with your notion. If that was a choice given to the person, and it was understood, why wouldn't?
But I mean, your therapeutic point is it seems to me the right focus for this. Whatever is therapeutically best is the
Whatever
kind of thing we
works.
The other thing you have to recognize with different jurisdictions, they may have different durational periods. So if you place yourself on a self-exclusion list in Massachusetts, for example, and it's 3 years, does that mean you say, I want to be placed on another state, does that mean you go on the lifetime self-exclusion in that other jurisdiction? So there are variables that need to be examined.
I think another variable might be section 45H and an interpretation of that section, which seems to prohibit the sharing of the list to any other than the affiliated casino of the casino that is maintaining the list. Notwithstanding any other general or special order to the contrary, the self-excluded persons list shall not be open to public inspection. Nothing in this section, however, shall prohibit a gaming establishment from disclosing the identity of persons on the self-excluded persons list under this section to affiliated gaming establishments in this Commonwealth or other jurisdictions, so on, which doesn't seem like it authorizes, it may not authorize the sharing of that list with other casinos other than the ones affiliated.
Would that extend, in your view, to a voluntary sharing at the request of the self-excluded person? It seems to me that if that's designed to protect the person who applies for the self-exclusion, that person could waive that.
But you're the judge.
No, I'm just
I suppose if it's a right that is afforded the self-excluded person, then that's a right that's, I suppose, waivable.
I don't think
If
it's free of
if-
ambiguity. I just don't want to let that that issue slide by without thinking about it.
In New Jersey, the courts actually said that a person cannot waive the confidentiality of it. It was an important public policy to maintain confidentiality. So when a case comes up in court, the initials are used, the name is not used. There was a case that I was involved in, the person was trying to be removed from the list. And the court went to great pains to hide the identity of the individual, only using initials in the court caption. Although the person wanted it to become public and was speaking freely to the press, the court would not acknowledge that.
The whole point, I think, of Commissioner McHugh's line of thinking, and I agree with it, is if a person
wants to be precluded broader than just Massachusetts, there ought to be a way to do it, you know, and we're certainly going to explore the compact idea, and it seems like there would be an awful artificial barrier if a person was unable, when he signs up for the Massachusetts list, to also sign up for the rest of New England if there's a compact.
There would be nothing which would prevent a person from signing up for as many casinos as they
that's
wanted
right.
to.
That's right.
So it's not as if they're prevented from doing that, it's just whether it's automatic.
Yeah, it's whether or not we can or
Right.
should facilitate that.
Facilitate, right, yeah.
It would become a question if we have a certain rule and you sign up for our program at 1, 3, or 5 years, and, you know, we'll extend your self-exclusion to other jurisdictions that may have more stringent requirements. That would, in some respects, put us in a position of, okay, you've signed up for the Massachusetts program, you know, should we have to fully disclose what every other jurisdiction's self-exclusion is going to be if you want to have your documentation extended to another jurisdiction? I don't know what.
Well, it sounds like
position
no one
that would
else at this
place us.
point would accept it, because
Right.
no one else is doing this. So we could say, hey, we'd like to give you this, but it doesn't sound like anyone else is in a position to.
Well, I think
Not only that, but jurisdictions have refused to help each other out to this respect. A new jurisdiction, as inquired of an existing jurisdiction, is so-and-so on your self-exclusion list.
Yeah.
And the answer will invariably be, we are not at liberty to disclose that information.
That's right, but that's because they haven't given and that's the way the law is written, and they haven't given the person the choice to say, I want my information shared. I don't think we can solve this.
There's an analogy, once you get past the issue of whether the person can waive this confidentiality, and if they can waive the confidentiality, the analogy would be with the non-self-exclusion list, the involuntary exclusion list. Jurisdictions share those lists all the time. So that once you're placed on an involuntary exclusion list in one jurisdiction, you're almost automatically placed on every other jurisdiction's involuntary exclusion list. So if there's a waiver of the confidentiality issue, there would seem to be there would be an ease of facilitating the sharing.
When I first was asked to do this, and I went to Mohegan Sun before we even started, I went to Twin Rivers. I met with the lottery who runs the casinos in Rhode Island, and they brought up the idea of a regional compact for self-exclusion. You know, so it seems to me I'm sure there are pros and cons, but it seems to me something we absolutely, for the self-exclusion as well as the other, something we ought to actually talk to people about. We ought to talk to the problem gambling people, and we ought to talk to the jurisdictions and see if they don't want to participate. Fine, that's the end of that. But if they do, then I think that's something we should seriously consider.
I want to build off this question, the topic a little bit, and go back to Commissioner Zuniga's point about where physically a person would have to go and sign up. I mean, I would think our overall goal would make that as easy and less onerous for a person to do as possible. But because we are granted a jurisdiction to approve the layout or modifications to the actual gaming floor, can we extend that authority to defining what the process for going on the self-exclusion list?
Regulations would do that. Regulations would set forth the parameters for how someone is to place themselves on the list, where they go, what they need to establish. And because you will have a casino, a gaming establishment in the western part of the state, will there be a commission presence there? And that'll all be worked out through the regulations.
Because, I mean, to his point, you know, the issue was raised with the compulsive gambling folks of, yeah, you could go sign up for the self-exclusion list, but, you know, it's in the middle of the slot floor. Well, that 100 yards, you might be tempted to give it one more shot and pull yourself, you know, decide not to get on the list.
What we did in New Jersey is the place that most people would come to would be the commission's office in Atlantic City, but we experimented with remote locations so that someone from northern New Jersey, for example, might be able to go to, and people actually did sign up for them. There wasn't that many, so the program didn't last that long.
Any jurisdictions that do it online? Or is there more detailed?
No, I think well, I can't say with a certainty, we would have to look at it, but I think the notion, again, is to have a face-to-face and make sure that the person is signing up in a voluntary capacity. The problem with online is you could have a family member sign up another person to be a spouse, for example, or a child to be on the self-exclusion list. That's not the intent of the legislation. The intent for the legislation is you place yourself, not another family member on the list. So I don't think online would work.
Yeah, and by the way, location may have a way in factoring in, this notion cuts both ways. It cannot be too easy, but it cannot be too hard, I guess.
Precisely.
For those reasons.
This is the good Catholic in you, I think. It's really hard. If you're gonna try to swear off, make it hard for the guy. Let's have our AA meetings in the middle of the bar. Really.
One more, you had asked about whether or not the
I was
exclusion
never a
had to...
good Catholic, by the way.
One more point, you had asked whether the exclusion had to apply to the whole entire facility, and just as a point of interest and maybe consideration, the definition of gaming establishment in the Act gives you the discretion to basically define what is considered the gaming establishment. It's the premises approved under the gaming license. It says which may include but shall not be limited to hotels, restaurants, or other amenities. So there is a discretion there if you wanted to have an exclusion from just the gaming area.
Yeah.
Good clarification.
That cuts a lot of different ways, I think, which.
It is.
That-
When we examined that and we had discussions, we were looking to see if we could, in fact, limit the gaming establishment because we thought it was too broadly articulated in the statute. But our discussion, and although we didn't reach a firm conclusion, was that it was intended to extend to the non-gaming amenities. That's why they included the hotel and restaurant language in there. If the intent was to limit the gaming establishment to the gaming area, the statute would have said that, and clearly could have said that, but it did not. So I think that the more logical interpretation, unfortunately, is that it's a broad definition of a gaming establishment.
So the more we discuss policy issues, the more questions we have.
Policy question, yeah.
And you will have them from now
Till the
until,
day we die, right. You know what, but I do think when we get to this again, I think having the problem gaming people here for a series of
I
these
agree.
questions would be incredibly interesting.
That should be a meeting to address all of these
Yeah, they
questions.
are.
We should send it to the head of the.
well-versed in this area.
Okay. Just looking at Lori catching up.
Oh, sorry.
She needs a breather.
Mr. Chair, I have another question.
Okay.
Question 48, what criteria should be used to exclude individuals involuntarily from the casinos? And again, 23K is quite specific on this issue. The commission by regulation shall provide for the establishment of a list of excluded persons who are to be excluded from a gaming establishment. In determining the list of excluded persons, the commission may consider, but shall not be limited to, whether a person has been convicted of a criminal offense under the laws of any state of the United States that is punishable by 6 months in a state prison, a house of correction, or any comparable incarceration, a crime of moral turpitude, or a violation of the gaming laws of any state, whether a person has violated or conspired to violate this chapter relating to A, a failure to disclose the interest in a gaming establishment for which the person is required to obtain a license, or B, willful evasion of fees or taxes, whether a person has a notorious or unsavory reputation which would adversely affect public confidence and trust that the gaming industry is free from criminal or corruptive elements, and the potential of threat to interest of the Commonwealth and the gaming establishment. No person shall be placed on the list of excluded persons due to race, color, religion, national origin, ancestry, sexual orientation, disability, or sex. There was some public comment on this, in particular Sterling Suffolk listing that we should include known cheaters and swindlers and members of organized crime cartels. Nevada statute and regulations and Mississippi regulations provide good examples of regulatory language. Nevada includes persons convicted of felonies, crimes, I think our law was taking crimes involving moral turpitude, violations of the gaming law in other state. It also includes those who violate Nevada gaming laws related to disclosing an interest in all gaming establishments that would require a license or willful evasion of fees and taxes. I mean, the law takes that verbiage almost exactly from Nevada, it appears. Mississippi has a very similar list of its gaming regulations, to which it adds persons who are on a valid exclusion list from any other United States jurisdiction, and let's see, they also note that a gaming establishment, like any business owner, will have the right under Massachusetts common law to exclude from its property any patron it does not want on the premises. If the person does not comply, the establishment can enforce the ban through a Massachusetts trespass statute. And then Mr. Cataldo says that people should be excluded only if they have committed a crime and the police have called to arrest them. Otherwise, why exclude them? So it seems like the legislature, pretty much verbatim went to Nevada's law, and that the language is almost exact. And that in discussing this, those are all important factors. The one thing that the law does not say, which is also a recommendation here, is that we consider those individuals that are on the excluded persons list in other state. But in an earlier question, they tell us to do that. They tell us to enter into a compact so that we have that information. So, Suffolk basically tells us that they like what Nevada has. Obviously, our legislature liked what Nevada had as language, and I think that is all language we could include.
Mississippi apparently does, but Nevada apparently does not exclude people who are on a valid list in any other jurisdiction. Do you have an opinion on that?
Well, yeah, I think it's, in an earlier question,
No, whether we consider it, yeah, not whether we should do it or not, yeah.
Yeah, no, I think that makes sense that we use that information.
So that's the involuntary list.
Yes, this
The
is
involuntary
involuntary,
list, right,
yes.
right.
So I think because it was answered in another question.
Seems to me this is a good approach. My only concern is the suggestion that, like any business,
Right.
they have a right to exclude anybody they don't want on their premises. I think that is a little broad. I don't think that is entirely correct. I think there are limitations on exclusion of people from places of public accommodation, for example, and other things. And I think we need to research that a little bit before we write that into some regulation.
Well, and what about the issue of precluding somebody because of their reputation? That someone of bad reputation might.
Right. I would like to see what other jurisdictions have done there and how they've defined that, and the fourth one, potential of injurious threat. I mean, that's what the statute says.
Mm-hmm.
Right.
I think we have to define what we mean by injurious threat to the interests of the Commonwealth, because otherwise we have.
It's pretty broad.
Well, it's not only broad, but it's very hard to figure out what it means.
Yeah.
And I think we need to help people understand what it means. I'm sure there's some.
Roman numeral 3 there seems to be, for whatever reason, they didn't actually expressly state that it should pertain to organized crime associates, but that certainly if you were an associate of organized crime, you would fall under Roman numeral 3. I mean, the key there is more than the reputation, is that it will adversely affect public confidence and trust in the operation of the gaming establishment. That is the key fundamental policy ingrained in the statute, to foster public confidence and trust. Without that, the gaming.
Right, I understand that, but it's the discretion, you know, what about Manti Te'o? You know, he's got an unsavory reputation at this point. You know?
Well, no, but that wouldn't have the second clause. That would not have the, I don't think his defense attorney, but that does not
myself from that comment.
affect public confidence and trust in gaming activity. It might affect his draft status.
Well, it's just a matter of what the law would permit. I mean, I'm only raise it because it seems to have it be merely based on somebody's notorious or unsavory reputation, which we judge would affect. I don't know what the law would permit there. How discretionary can we be on that? I don't know what the answer to that is.
You have very broad discretion. Very broad discretion. The courts have uniformly supported regulatory agencies in the placement of someone on the involuntary exclusion list. You have broad latitude. Now, there will be due process procedures in place for someone who wants to contest being placed on the involuntary exclusion list. It's not an automatic process.
Are there regulations elsewhere that define concepts similar to 3 and 4 in this statute?
Usually there's case law. For example, New Jersey uses the nebulous term inimical. If someone has conducted activity that is inimical to the interests of the state, they're to be placed on the exclusion list, and there's case law as to what that means. It's essentially the same concept here, where the public confidence and trust in the operation of the gaming establishment has been negatively impacted by someone's presence in the facility. Now, what does that mean?
But you couldn't.
5 individuals, and you might have 5 different interpretations of a particular person. Is that person's reputation undermine public confidence and trust? You may feel it does, and you may feel it doesn't, and that's why there's 5 of you.
5 talks about the potential of injurious threat to the interests of the Commonwealth. I suppose literally that just a threat to the interests of the Commonwealth wouldn't justify an exclusion.
Well,
Not sure how you slice that one, though.
That's a very vague term, and I'm not familiar with that in other jurisdictions. I mean, we'll do research, obviously. That is
Being
intentionally
somewhat
vague.
facetious there, but.
Yeah, injury doesn't have to be physical.
Now, the point that you were making before, Commissioner McHugh, about whether an establishment can exclude someone, unless it's for discriminatory reasons, they are at liberty to exclude persons from the casinos, and they will generally have a list of people that they don't want in the casino. And it could be because they win too much, unfortunately, and there's a notorious case of that, where someone was very successful with beating the casinos, and they put them on their exclusion list because they didn't want them there anymore.
Right, and I can understand that, but all I'm saying is if you apply that to casino or the gaming establishment as defined in the statute, that includes the hotels, the
Right,
restaurants.
that's a
all this
good
other
point.
stuff. And there may be place of public accommodation regulations that kick in at that point. All I'm saying is we got to be careful when we.
Yeah, and the other thing that to remember as we go forward, enforcement of this self-exclusion list and the involuntary exclusion list is a very difficult proposition for the casinos, particularly the self-exclusion list. Now, the involuntary exclusion list, there will be pictures of the people that will be circulated to the casinos, and the surveillance and security departments are trained to be on the lookout for these individuals. Self-exclusion list is far more difficult, and generally what the regulatory agencies are looking for is to ensure that people on the self-exclusion list are not extending credit and complimentaries and marketing material to induce them to come to the casinos. Unfortunately, sometimes that does happen. But it's very difficult if I am on the self-exclusion list, I show up at a casino, I walk in and I walk over to a slot machine, casino operator's not going to know that I'm on the self-exclusion list. That's not going to be easily determined. So it becomes, it's a tricky, it's a double-edged sword.
I was just going to address actually, Steve just made the last 2 points I was going to make. The one thing that we haven't discussed at all about exclusion is the burden that's on the operator to do the exclusion. That is something that is real, and there is regulatory penalties that, can be significant on a violation in that regard. And just another thing on the exclusion list, self-exclusion list in Massachusetts, the statute does provide for, obviously, the confidentiality, does allow disclosure to affiliated properties, but not to other properties right now. So, for example, if I exclude myself in Boston and a casino is here, and then there's another casino out west, that self-exclusion would not apply there, at least sharing of that list, unless I exclude myself there. So getting back to your point, Commissioner McHugh, about, we could research whether a voluntary expanded self-exclusion could be included, but then you have to evaluate what is the burden on the individual operators. If I do that in one casino and extend my self-exclusion and maybe a broadly based waiver of my confidentiality rights to the other casinos, there has to be a provision for a notice to the others and so forth, so that they can enforce that and be held to that standard. And then secondly, with regard to what Steve said, I just wanted to add, we have a long experience with what we euphemistically call the 86 list, which is the casino's own self-exclusion. And that's often confused by the public. The casino routinely, on any given night, will be excluding drunks, people that act up, a variety of different reasons, that never reach the exclusion list. People hear exclusion, I was excluded from the casino, they think your name is published and you're on this, nefarious list for the rest of your life. Self-exclusions are completely separate. But 86 list or the type of daily exclusions that casinos are involved in are very routine. Generally, they're for 24 hours, 48 hours, sometimes a week or two. And
Could be called
generally you can
Deep
be,
Six.
Pardon me?
Could be called the Deep Six list.
Deep Six list, right. And there's even, more progressive casinos will have their own list of those persons separate and apart from the formal exclusion list, where that list, where you don't get back in, for example, until you come back in front of an 86 committee or a Deep Six committee that could be composed of security and maybe a casino manager and some other people who look at it and say, well, this person's been drunk 3 times in a row. We've had to put security measures on him. We had to, arrange for transportation home. We're going to bar him for 6 months till he straightens his act up. So there is that other level of operator-generated exclusion that will protect to a certain degree the public against themselves and the property against itself too.
I want to pick up on that point because, Roman numeral 3 is really broad. And it gives, as Steve suggested, we do have a broad authority allowed to us under this section of the statute. But, I have a question about putting a burden on an operator to essentially be mindful of anybody convicted of a criminal offense that's been punishable by more than 6 months in a state prison. I mean, I would have to harbor a guess. That's a pretty sizable list in the Commonwealth.
Well, they have to be on the list.
What happens is that the agency that is entrusted with responsibility for requesting placement on the list, now let's say it's IEB. I'm not sure who's going to be actually doing this.
All right.
Let's say IEB presents a case to the commission to place someone on the involuntary exclusion list. They have discretion. They will not be bringing everyone who's been punishable by more than 6 months. That's impractical. They have, as the criteria, all they need to establish is that person has been convicted of a crime that's punishable by more than 6 months in prison. But they will not be bringing every single person who's been convicted in the Commonwealth.
Okay.
For more than 6 months.
All right.
And one other area that I wanted to mention and we'll examine is that sometimes there will be a court order, for example, and a condition of probation is that an individual has to be put on the exclusion list. That's something to examine. It's not in the statute here in Massachusetts, but it's something to explore in terms of whether you wanted that in a regulation. That is a frequent condition of probation.
A little bit off subject, but related. To what extent, in your experience, in your collective experience, is face recognition software used to enforce the prohibitions of these lists?
We've, one of the other casinos we advise on regulatory matters has received some demonstrations of it, and they're using it in Vegas, and I know they were trying to use it in Connecticut. I'm told it works, okay, and it's pretty effective. Is it enough now? Casinos, for the most part, have not gotten away from the traditional hard pictures and so forth, and now obviously it's on screens and in databases and so forth. So it makes it a little easier, but it appears to be a technology that will work. It's not a replacement for, vigilant surveillance monitors. Again, there's more than one way that, you'll see things like between the pit bosses and the dealers, they'll make certain recognitions, and there are certain responsibilities in their training, but, obviously, no one can remember a whole book of faces, but it is certainly an aid, and I think it does have a real future. Now, to what degree, certainly a match that can be conveyed to the floor, and then a further verification for identification is not an unreasonable step. You've probably captured more than, waiting for the person to be seen. So I think there's a promise for that technology, I really do. Would we try to require it by regulation? That's, that might be difficult, but would be certainly worth exploring, in terms of your evaluation of the surveillance department and the commitment of the applicant to maximize their policing of the exclusion list.
I've heard anecdotal stories that go both ways. Some that they've had positive identifications and have turned out to be the person, but there have also been instances that I've heard that there were misidentifications. So that's an area that needs to be examined. But the face recognition is an area that is becoming, through increased technology, it's becoming better and better as the years go on. But it's certainly something to examine. The industry, again, the focus that I have experienced is that they are predominantly interested in preventing the people on the involuntary exclusion list from entering, because they know that the fines that they are likely to receive are quite high, as opposed to if someone is on this self-exclusion list. The self-exclusion list, I think their focus, right or wrong, is to make sure that they don't market promotional activity to the individual. They're not on the mailing list any longer, and that they don't issue complimentaries and credit to these individuals, but not so much as preventing them from entering the establishment in the first place. Although they are obligated to do that, I think that takes a second seat to their other, what they consider their other responsibilities.
And just one last point I just wanted to make on item number 3, because there was discussion about the notorious or unsavory reputation. This commission will develop its own body of jurisprudence with its own interpretive decisions as this goes on. And, you do have a body of existing gaming law that have relevant terms in there that can be useful in forming it. And, your future in crafting opinions in cases when they're raised, when someone challenges the commission's placement on this list for example, item number 3, those initial decisions are critically important going forward, because they're the foundation on going, for building on your jurisprudence in the future. And I mean, there's decisions, not with some, not to give my partner his more kudos than he's entitled to. There's been some in the past that he has been involved in his authorship and so forth that have been found effective. Steve too, for that matter. But those decisions are important, and we certainly have every confidence that you will be rendering those kind of opinions that will be the strong foundation for future jurisprudence in this area on those interpretive ideas.
Another item while on the subject of exclusions to recognize is that a person who is placed on the exclusion list is not permitted to keep winnings if their identity is disclosed, or recover losses. So if you're on the exclusion list and you lose money, and then you say, well, I should not have been allowed in the casino, so I want my money back. Well, they've already acknowledged that they cannot do that, and that's been supported and approved by the courts that have considered the issue. So it's a roundabout way of saying, in terms of the responsibility of the casino, they might want to bring someone in knowing that if they are found out, they're not going to be able to recover their losses. So it's like a free gambling activity. You would hope that the casinos are more responsible for that. I'm sure they will be here.
Okay, thank you.
Thank you.
Great. Shall we take a quick break? Take a 5-minute break?
Sure.
Sure.
Okay, I think we're ready to reconvene of the 48th meeting of the Gaming Commission. And we will go to key policy question number 50, which I believe is Commissioner McHugh. Is that right?
No.
No.
Oh, sorry.
That's me.
Which I believe is Commissioner Stebbins.
This, Mr. Chair, I think was a question that came in from the request to the public if they had additional questions to ask. But the question is how should the role of the commission be defined in the licensing process? What other departments, if any, have a role in the licensing of certain occupations? Will the commission be licensing on the basis of suitability only or skills and education as well? Will licensing be limited to occupations closely associated with the gaming area? Obviously, I have listed the relevant sections as I saw it. Excuse me, under the statute, sections 2 were the definitions for the following employees, section 5, section 16 and 30. Section 30 is one that we haven't really talked about, that establishes no person shall be employed by a gaming licensee unless such person has been licensed by or registered with the commission. Section outlines the suitability measurements of a license required candidate must have prior to employment. Per this question, there doesn't seem to be any ambiguity as suggested by this question about what the licensing role is of the Gaming Commission. Obviously, IEB, other investigative agencies are critical to background checks, employee license approval process. And a further question we're going to address, in deciding whether to license training schools, we would be establishing minimum training requirements through the MOU between us and the Casino Careers Institute. Our goal is to identify a base level of skills for potential employees. Again, because I think this was a question generated by the public, we didn't receive any written submissions on this question. And my recommendation is certainly review section 30 with respect to information required for employees who need to be registered. But, and additionally, we can create minimum training requirements if we decide to license training schools. But in answering the question, I don't think there's any ambiguity in terms of what our role is and what we're required to do by statute in terms of licensing.
I had a couple of questions about this one, which feeds back into the discussions that we had earlier when we were talking about the MOU with the training schools, and I'm not sure we ever fully resolved there. The first one is, are we awarding licenses on the basis of background, or are we awarding licenses on the basis of background and skills? And if the latter, what are we going to do about verifying skills? The statutory criteria seem to focus primarily on background. The jobs are available only to people who meet the establishment's satisfaction in terms of their training level. And so that was the first of the questions that I had. What, as a matter of policy, are we going to do there, and what are we going to take on? A second, are we going to issue licenses with only to people who already have a job, or are we going to issue licenses to people who then can be turned loose to look for a job? There's a very different load placed on the IEB depending on which of those choices we take. And I think about that little memo I sent from the trip to Mississippi, where the license is actually issued to, or delivered to the gaming establishment after it's offered a person a job. That's not the only way to do it. In fact, they do it down there. They issue a license before the person goes to a training school.
A student license.
A student license, yeah. And so that was a second question. And then a third was, we've got also licenses we have to think about with respect to gaming vendors. And I think you must have excluded those from this, and maybe that's a separate set of considerations, Commissioner. But the same dichotomy is there as well. Do we issue gaming vendor licenses on the basis of background or background and competencies? And if the latter, we're really into a broad array of areas that I think we have no competence at all in. Then insofar as training schools are concerned, there's a question in my mind about licensing training schools, a function that's now in the DPL, and we've talked to them about how to collaboratively work with them, or whether they do the licensing, but we do the certification. In other words, anybody can open a training school if they satisfy the DPL's regulations, but only training schools that comply with, as they determine, with our criteria can get a gaming commission stamp of approval on them. And if the latter, which administratively is certainly easier, what does that certification get people in terms of assistance in getting a job, when in the end it's going to be the gaming establishment that's going to determine who to hire. So those were some of the questions that it seemed to me that as a policy matter, before we get to writing regulations, we need to think through. We've touched on all those. Those are all implicit in what you suggested here. They're all bound up in the statute and the regulations and in our prior discussions. Whether we need to resolve them now or not, I don't know, but they seem to me to be things that we need to think about before we start to take pen to paper and draft regulations.
I did look at this question probably more narrowly focused on occupations related to the licensee, the gaming licensee.
The gaming license, yeah.
They mentioned role in licensing of certain occupations. I guess I assume that, or because it said occupations as opposed to vendors or suppliers, they kind of left that part out of the question. So I kind of kept it limited. You know, we do have another question coming up about, you know, should we be regulating private training schools or public training schools, or establishing that bare minimum of training experience? You know, my thought was, and we've talked about this, you know, we don't want to necessarily lead people into thinking casinos are coming into Massachusetts, I'm going to go for a job in a casino, not understanding the criteria which is laid out, which may make them ineligible to pursue a casino career. And, you know, as opposed to going through background check licensing for everybody who wants to follow that route, but by being more proactive and say, you know, we're sorry, but essentially everything that's listed in the statute probably would make you ineligible, and that's something for you to consider. But moving towards doing an investigation or a background for a person who is has been trained and is interested in pursuing, you know, a career opportunity eventually with one of our licensees, I think that begins to focus our IEB resources more on someone who, I mean, we don't even know why somebody might go through a training school. It might be, I want to learn how to deal blackjack, but I may never become a casino person. So I think using our investigation and licensing resources for that person who is going to be offered employment or is taking the next step, or at least a step closer towards gainful employment by a casino operator, I think is where we want to direct some of our licensing and investigative resources.
And why wouldn't we wait until that person has a conditional job offer pending a license?
Why wouldn't we wait to run them
In other
through
words, yeah,
that?
why would we license someone who doesn't have a job offer? And the reason I mention that is because if we conduct a background investigation and 6 months later they don't have a job offer, that's an incomplete background investigation.
Right, I'm suggesting licensing or doing the background check on somebody who is
Has a conditional job offer.
conditional job offer and is ready to be assumed taking a job.
Okay, I'm sorry, I misunderstood you
Commissioner-
to mean that
That's all
they.
right,
Okay.
I frequently confuse myself. But I think to Commissioner McHugh's original question of where do we begin to stake out that licensing investigation, I would do it, again, when that person is ready to be employed. I think if we do it at the front end, we'll be using up a lot of invaluable resources, where I think publishing information about what the base suitability
Yes.
requirements are going to be, hopefully somebody out there can assess for themselves whether they're going to be, have an opportunity of getting a job within a casino.
A point on that that I'd like to make, in New Jersey, there was no requirement that a person actually have a job, and people frequently use New Jersey as the training jurisdiction, so to speak, because if they can get licensed in New Jersey, they would then be able to market themselves in other jurisdictions. And there was considerable expense, as you can tell, for having this person go through the licensing process where the person had no intention at all of actually working in Atlantic City. So the commission has the prerogative of requiring that, although the statute does not mandate that. Some statutes do, yours does not. Temporary licensing section of the statute does. That speaks to the fact that a casino needs to establish that it is urgent that that person receive a temporary license, and that urgency necessitates that the person have an offer of employment, otherwise it wouldn't be urgent. However, the statutory sections that deal with key licensing and gaming employee licenses do not mandate that a person have a job offer. So that is a policy issue for the commission to examine.
And the countervailing argument in terms of not requiring a job would be that it creates a labor pool for available employment because of the high turnover. Should there be turnover in a casino, the casino doesn't have to wait any period of time before they can find someone to replace those who have left. There are available licensed people out there who can just step in. I'm not saying that countervails all the expense and time and trouble of licensing people who aren't going to be using the license, but that is the other side of the policy argument.
Particularly at the, well, I just thinking particularly at the outset. I mean, the process for, if 2 or 3 facilities are opening around the same time, we're going to have thousands of background checks to be done.
That's correct.
Yeah, that's why Ohio, which was a recent jurisdiction to implement gaming, required the job office for that reason, to reduce the number of the background suitability investigations that would have to be undertaken. They had a finite number of casinos opening, and they did not want to have to go through a lot of background investigations for people who were not going to be employed.
And that, we can both tell you about the nightmare of the beginning of New Jersey when they were flooded with thousands and thousands of applications. It was commonplace at the Casino Control Commission meetings there for people to line up down the hallway and down the stairs and out into the parking lot to find out what the status of their license applications were, because they had left their homes in some other state and moved to New Jersey on the expectation that they were going to get a job right away. Their licenses were being held up because they just couldn't be processed fast enough, and it was a very difficult time.
That was the angle that I was thinking, that maybe particularly at the outset, you might want to license people, start as early as you could to create a pool, because if you had to do it all at the same time, you just.
But the companies know when about, and they'll be planning ahead of time too. They'll be starting their hiring process well in advance of the opening.
Well, that's something we could probably coordinate with them on that score,
Correct.
yeah, right.
Yeah, I think Fred had mentioned that yesterday, in yesterday's session, that you'll be here at your regular public meetings. The applicants, who have been, actually they'll be the gaming licensees at that point, will be coming forward during the construction phase and updating you on their hiring practices, how many people that have applied and how many people have been actually interviewed and screened, and so you'll be getting periodic updates.
Can I, sorry, I'm sorry.
If the licenses are issued in advance of a job offer, is the license issuance based on competency plus background or just background?
Competency as well, yes.
And how is competency tested?
And that's because of your statute competency.
Well, either because of they'd be tested on the basis of either a graduate of a gaming school or prior experience. Many people came from other jurisdictions where they had worked in casinos in the past.
So the licensing board doesn't set up a test or a...
No, it's a subjective evaluation, either the fact that, it's not subjective if they've been certified by a gaming school or if they have worked in the past at a similar position.
That's why the job offer may play into that, because people coming off, proverbial off the street with no experience at all would not be able to be licensed under that stringent criteria. Whereas the gaming operators will filter through applications and determine which people they feel have the necessary experience for the position.
On the other hand, you'll get gaming schools open who will try to get the largest possible class they can and spit out a large number of graduates, so that there will be a lot of trained people on that basis as early as possible.
Well, one other point, this is an unusual way that statute is written. Again, it's because of the broad the definition of a gaming establishment, but it speaks in terms of being qualified for positions within the gaming establishment. Taken to its illogical extreme, that would include housekeeping people. I don't think the commission has any intention of requiring, pre-qualification for people who are actually working in the hotel. The focus is going to be in the gaming area. But the statute does speak in terms of positions within the gaming establishment.
But it breaks out gaming service employee
employee
here as not needing, needs to be registered with us, but not licensed by us.
Well, you have to be registered, I know, but it also speaks in terms of regulations, section 512, speaks in terms of regulations that you are properly require that all gaming establishment employees be properly trained in their respective professions. I don't recommend an interpretation that would extend that to the hotel, but read literally, that does pertain to the hotel.
But I think that's may. This isn't must. This says we
Right.
have the authority to do that if we choose to, but it doesn't say we have to.
Yes.
What does Section 30 say? What are the requirements under Section 30 that define our licensing? It says we should review Section 30 closely. Does somebody have Section 30 closely?
Yes,
Right
I
here.
know that's section 30.
Information required of employees need to be registered. What is that? What does it require? I'm speaking to now. I'm interested in the issue of suitability versus skill.
Well, subsection B starts to differentiate the key gaming employee to have an application with the Bureau, which would include a lot of language here relative to background check, including financial records.
Just speaks to the suitability, not.
Just speaks to suitability, right, not to the skill, but it's a.
I'm not sure we're not making a false distinction. A person's business ability or skill can be considered part of their suitability. You don't
But I'm
want
trying to find-
you may not want to license a CFO who has never taken an accounting course.
Well, why would they hire anybody who doesn't have an accounting course? I
Well,
mean, it seems like
that's,
it's
you know,
not.
it's not, yeah, you're correct. It
Right, I mean,
seems like it shouldn't
our
be.
job, our job goes to suitability. I'm looking for words that make a distinction between, your integrity, your character, your your criminal background, those kinds of things, from your ability, skills to do the job. And offhand, I don't see why we ought to get involved in whether or not you have the skills to do the job. I mean, we do have an interest in preparing the workforce because that serves the interests of the Commonwealth. But I don't see why we would need to be double checking anything, whether you can make a bed or whether you have an accountant's degree. I mean, that seems, that seems to be outside what we need to be looking into.
Along those lines, most jurisdictions are getting away from looking at business ability. Business ability was a condition imposed in the early days of legalized gaming. But as you say, other regulators have taken that approach, that is an operator's prerogative to determine who they should hire to be their CFO. And that should not be something that the regulators impose. However, you do have to measure that with the statutory requirements. Now, I think what the legislature is looking for is they want to make sure that a dealer is properly trained to be a dealer.
Well,
Now, the casino itself has it's in their self-interest to make sure the dealer is properly
And
trained.
that was my point. I don't see the distinction. Why, if you don't care if a CFO has an accounting degree, why would you care that a dealer hasn't been trained? But the statute does require you to care about the dealer's training.
Where does it,
Well, there is the,
where is that? That's what I was looking for.
Section 5,
512.
Section 512 talks about.
But that's gives the authority,
Properly trained and required.
We don't have to do that.
and may establish.
Right, you don't have to, but
So
it's kind of signaling. I mean, I look at that as that it's signaling to the commission that to some degree, whatever degree that is, that's in your discretion, you should be examining that. There may be certain positions that you look upon, perhaps, for example, a dealer. You've already indicated you're not gonna, you wouldn't worry about a hotel, and everyone would wholeheartedly agree with that. But there may be certain positions, a slot mechanic, a dealer, the people who are close to the money, be properly trained. Again, it's in the self-interest of the casino establishment itself to make sure that their employees are
Could we,
trained.
for all intents and purposes, make this somewhat simpler and say, okay, training school, you are required, if you choose to offer training courses in the Commonwealth of Massachusetts, here are the basic requirements of the courses that you're going to offer. 18 hours training in blackjack, et cetera, et cetera. And then this commission simply adopts those and says, it's not only your suitability, but making sure we're establishing or requiring whatever we're requiring the schools to teach. I mean, that would seem to be a simple way to get to it. I mean, I do understand, requiring gaming establishment employees to be properly trained. I mean, I think by doing that, we are, hopefully securing some integrity to the process, that I go into gamble, there's some relative expectation the guy who's dealing with cards has been trained, knows what he's doing, so that, you're building the credibility and integrity of the operator. But again, we're going to talk about training schools in another question, but it may be simple as that. Whatever training requirements we establish for a private or a public training school to offer be the base requirements to add to the suitability for a gaming, a gaming employee or a gaming or a key gaming employee. Just do it simply that way.
Well, that is a neat way of doing it, I agree, and I'm just not sure that I'm wrestling with whether we have an appropriate role at all in that. What, I'm trying to, as you're talking, I'm thinking, we don't test nurses, but we do test contractors. I mean, what's analogous, where is the public interest here? Is the public interest served by us making some kind of substantive judgment about the professional skills, whatever level of profession it is, of the individual?
Can't we, I mean, here's a place where our interests and the gaming operators' interests are directly aligned, right? We want people to be able to go into a place where there are competent people at the tables and competent people taking care of the machines. So does the gaming operator. Is there any jurisdiction that requires the operator, as part of its application or otherwise, to state the criteria and qualifications that it will demand of its employees, and then have the commission either approve or disapprove those, and leave both the enforcement and to spot checking whether or not the workforce in fact complies with those requirements. That's one that would put the expertise where the expertise logically resides, and at the same time ensure that the public was protected by a menu of skills that each person in each position would have.
Yeah, I'm not aware of any requirement that's specific, but there are requirements that a casino's personnel handbook, personnel policies, and training manuals be approved by the agency, which would be a similar kind of, I mean, it's not specified, but but as a condition of licensure and as one of the internal controls, you would require that those kinds of training manuals and so on be approved. And I would think that that's probably what the statute's talking about. I'm not sure it's permissive. It might be mandatory in 511 that says establish licensure and work, shall establish licensure and work permits for employees working at the gaming establishment and minimum training requirements. That's how you interpret that. That's a shall.
Yeah, that's a
511
shall
is
from
because
That's a shall.
in the summary here, it's not.
No, all of 5 is a
All of
shall.
5 is a shall.
It's actually, I was going to read that shall,
Okay.
11 and 12 taken together.
The permissive is later on where it says, provided, however, that the commission may establish certification procedures for any training schools and the minimum requirements for reciprocal licensing. But it's a shall establish minimum training requirements.
And Section 12 is also mandatory.
That's what I
Section
got.
5 sets forth regulations that are mandatory for the commission to promulgate, and 11 and 12 speak to the subject, and they would be mandatory requirements. And then the discretion is, how far do you go?
Right. How specific do you want to make those? And approving a training manual would seem to comply.
Or as Commissioner Stebbins said, agreeing that they have to have met, had the same standards as we've given the training school.
Absolutely.
Some other kind of broad brush.
To speak before the question, Ohio had adopted something akin to what Commissioner McHugh had suggested with respect to their training programs. Again, they would do this at regular Ohio Casino Control Commission meetings. The licensee would come forward and, actually they were applicants at the time. The applicant would come forward and say that, well, we have opened up our training school or our training program, and 200 people have gone through it, or 500 people have gone through it, and they are now qualified to be employed by our establishment. It was not a requirement, but it was something that the commission looked upon with favor.
Yeah, I see this as maybe, a 2-by-3 matrix where there's a 3 distinction of levels of employees.
Yeah.
Key gaming employees,
For sure.
Service employees, et cetera, and there's a sliding scale, if you will.
On the
closer-
training,
on the training and the skill, the licensing and the certification.
So you're saying if you're a CFO, we would play more of a role in overseeing that you're a good accountant?
Yes.
So that seems wrong to me.
Well, no, I'm sorry. I'm saying relative to the definitions of key gaming employees and
Right.
service employees, for example, an accountant or anybody close to money would have more scrutiny necessary than housekeeping.
But more training scrutiny, not suitability scrutiny, is what you're saying.
Well, both, depending on how we define skill, which could be, as Guy was suggesting.
Okay, but suitability is character, criminal, et cetera.
Right.
Training is your ability to do the job.
Yes.
And to my way of thinking, we have a legislative mandate, which I didn't understand, so we have to comply with that. But my thing is, this is a place where we can get out of we don't need to regulate these folks on how well their people are trained. It's just not, there's no need for government to get involved in that. We got plenty of things we should be doing, but that isn't one of them, it seemed to me, other than complying appropriately with the mandate. just, I think Commissioner McHugh's, where our interests diverge from the casinos, where the public interests diverge from the casinos, that's where we've got to really pay attention. And if whether the blackjack dealer is subject to corruption, that might be in the interest of the casino, but clearly not the public. But that he or she be a good blackjack dealer, I think our interests are essentially completely aligned with the casinos. So why do we want to put a burden on them or us to do something they're already going to do in their own self-interest, which is make sure that people know how to do their jobs?
And maybe the answer really relies on just how we do that, whether by those manuals or regulation or a combination.
That's a different story. And how we've had two suggestions about relatively sort of simple blanket ways that we could meet that minimum requirement. One is to approve a handbook. Another is to make sure that they've at least gone through what we've set out as the minimum requirements in our training licensing programs. There are other ways to do that, but.
And they could be compound. I mean, you could get a certification or an out-of-state license plus approval of an employee handbook.
Right.
To make sure that skill continues.
And from the, again, we get down to another question on this, but as I've looked at other jurisdictions that do certified training schools, bare minimum requirements or required training pretty much are mirrored across all the jurisdictions. I mean, there's not much of a huge discrepancy in terms of the number of hours you get to learn or be trained doing blackjack and everything else. So it's a relatively, I think, a simple approach, but.
It's interesting, when we were in Las Vegas, we didn't connect the training program. Well, I guess those were service employees. Those weren't, no, there were other people. They were bartenders,
Food and
black
beverage.
dealers, yeah.
Yes.
We didn't track the relationship between the union's training programs and the regulatory role. I don't think we looked into
Did not.
where does the Las Vegas regulatory agency get involved when Unite Here is producing people?
I wanted to throw another area out for discussion, and it's very problematic in that the Massachusetts statute, like most statutes, you speak in terms of a license. If someone receives a gaming employee license, the licensee is able to put them in the area of the casino where they need them. For example, they may be in the slot area, but on a particular night, they may have to substitute to be a dealer, and they may not have the requisite business ability to be a dealer, but it's in the self-interest of the casino to put them there because they don't want to have an empty table. That is something to consider. And the jurisdictions that have required business ability have dealt so for that reason, to ensure that the casinos do not have unbridled discretion to put employees wherever they want to. They have to put them in locations where they actually have the skill level to do the job. Just something to think about. I don't have, it's not an easy answer, but it's a question that needs to be
Another reason why
wrestled with.
Posted for a workforce development.
Because of, because of the mandates in the legislation. And we've seen that. It's not just as a hypothetical. We've seen that in New Jersey.
If I may, I just wanted to point out one other thing, and this is more practical than theoretical. The training of employees and so forth, apart from the suitability and from, say, an assessment of competency, there's also, from an HR point of view, under Section 18 of the statute, there's a requirement that the applicant affirmatively demonstrate their human resource hiring and training practices that, requires the development of a skilled and diverse workforce. Okay, there's a particular affirmative responsibility they have. But there's other areas also that have to be addressed as this goes on. For example, your cocktail waitresses and so forth have to go through what's, again, euphemistically called a TIPS program, where you can recognize, persons that have overconsumed. You have to have a requirement, even with problem gaming, there's mandatory requirements for every employee to be that's involved in gaming to recognize people that are going over their heads quickly. Safety, OSHA, the basic stuff, usually found in an employee handbook. But the training that goes with the handbook, generally there's an employer HR department sponsored detailed training orientation program, which includes all of these major components that are required. as well as generally a regulatory orientation to explain the role of the Massachusetts Gaming Commission. And that's part of the training regimen that they get. So they understand what the commission does, what their roles are, what penalties they have for violations and things of this sort. And then there's subparts to that. You know, the state police, what do they do here? Security, what is it? What is its role? And a variety of these things. So the point being that you have a training, a competency requirement, whether it's mandated by regulation or left up to the operator. There's also a post-selection, say post-qualification, post-employment commencement, whole regimen of training that goes with the casino employee, casino role. And there's a fair number of washouts, even at that. Person can be licensed, person can be initially trained and get into some of these initial things and just not like it. You know, not like the shift work and not like a 12-hour shift or whatever else. Not unusual, okay? But the point I want to make, there's an expansive landscape of training that starts with, I want to become involved in a casino. And if a school starts it, you get certified, and you move through the process. By the time you get, you know, ejected at the end, you have a pretty good amount of training that you can take to other jurisdictions. But from your point of view and from what you should require, you know, obviously the suitability is critical. The competency is a sliding scale because you know they're going to have a lot of training coming down the road. And whether you mandate it or you make it optional for the operator, it will be done. I mean, they will receive this training. They almost have to.
Yeah. Well, that's good. That's a good
It's also
distinction.
implicit along those lines and in the statute that those receiving licenses will be for a period of time. After some time, they would have to reapply for a license.
Correct.
There's maybe refresher training at that point.
Absolutely.
There's maybe new methods that have been developed or new regulations that have
Right.
been issued.
And your
So these
disciplinary
all-
record may trigger additional remedial actions during it. For example, very common is cage irregularities. People that mishandle cash, mishandle fills, don't fill out the signature lines, don't follow the internal controls. Very common. Person may get 1, 2, or 3 violations of that, and they're just not equipped to handle cash well. So they'll go through a remedial course, they'll be put back in, they get the 4th violation. Well, maybe they move to another location where they don't handle cash. But the operator, it does coalesce. You have the interest of gaming with integrity, trained employees, and the interest of doing it right under the internal controls does come together at some point.
Yeah, that's a good addition to this thought process. Thank you. I have to go see Emily Rooney. Commissioner McHugh, do you want to, would you mind picking up and chair the meeting for the rest of the? Sure. Okay. Thanks.
Thank you.
Thank you all.
Chairman.
See you later.
Bye-bye.
See you tomorrow.
See you tomorrow.
See you tomorrow.
All right, the next issue, and there are 3 more, 51, 52, and 53, according to my tabulation here, although 33 is in here someplace, right?
Next one is 52.
Yeah, 52, the 51, I distributed this morning. Did everybody get
Yes.
51?
Yes.
Yeah.
I do.
I distributed last night.
Full punch.
Yeah, whole punch, it's wholly paper. 52 deals with, well, it says this: to address concerns regarding inappropriate pressure on casino companies, should the commission require applicants and licensees to report to the commission all resumes, recommendations, referrals, requests for donations, etc., they receive from any public official, with failure to do so resulting in a penalty. In answering that, I think it's worthwhile to divide recommendations, resumes, and referrals from requests for donations and other kinds of things, because 2 slightly different sets of considerations come to bear. The resume recommendation from public officials issue is one that has received a lot of attention recently in a lot of different contexts. And recently, in response to that attention, the State Ethics Commission issued a extensive advisory dealing with when it was proper for state and municipal and other public officials to make recommendations, and whether they could make them on their official letterhead or could not. And basically, it boils down to three intertwined factors. One, it's permissible for a state employee to make a recommendation if the recommendation is based on personal knowledge. Elected public officials are in a slightly different category, but for most public officials, they're permitted to make a recommendation if the recommendation is based on personal knowledge. They're permitted to use their official letterhead if that letterhead is relevant to the recommendation, i.e. if they're making a recommendation for somebody that worked on them in a particular capacity in the office that they are now occupying. And three, if the recommendation contains with it no express or implied pressure on the person to whom the recommendation letter is addressed to accept the person for employment or for any other position. In addition to that, state law now requires for all state employees that recommendations be considered only after the candidate for employment has been found qualified for the position, and that the recommendation become a public record if and when the person is hired, so that the public has an opportunity to know who recommended that person. So that's part of the background for the recommendation and referral piece of this. Insofar as other solicitations are concerned, there are a whole variety of public statutes, of statutes, I should say, that deal with it. Some simply prohibit certain kinds of gifts and solicitations for gifts, including statutes dealing with bribery. Campaign contributions are heavily regulated, as we all know, and they're regulated by our statute as well, as are in-kind donations to municipalities and municipal officials. Solicitations in general of non-political contributions are permitted under the ethics laws only if specifically authorized by law. And as I set out in this memorandum, the Ethics Commission has issued an opinion that deals with when those solicitations are permitted. And those would include solicitations for funds, for example, that the municipality is building to build a new skating rink or some other kind of municipal, worthy municipal activity. And again, the Ethics Commission is pretty clear in its opinion that the solicitation has to be made under circumstances where the person solicited, particularly those who are regulated by the municipality in some way, are not under express or implied pressure to contribute. To help ameliorate that pressure, the Ethics Commission, in its most recent treatment of this issue, said that a list of the solicitations should be published and maintained by the municipality so that people could see who was solicited and what the response was. It seems to me that the extensive treatment given by statutes and regulations to the subject of recommendations and references and to the subject of solicitations warrants us in treating this in a way that enhances public confidence through disclosure instead of prohibitions and the like. And so I would recommend, with one caveat that I'll explain in a second, that references or letters of recommendation for employment be disclosed on some periodic basis by gaming establishments. That all requests for solicitations they receive from any public official for monetary or non-monetary contributions, and all monetary or non-monetary contributions they make to an elected or public official or municipality be disclosed, again, on a periodic basis. We've already said that in the application, we've decided as a policy matter earlier on in our discussions that all contributions in kind to a municipality that are made by a gaming establishment from the time the statute was passed until the application is filed will be something we'll ask them to disclose in the application. So this builds on that on a continuing basis in a number of ways. The one caveat, and it didn't occur to me until I thought about this more on the way over here, is that requirement for a contemporaneous disclosure of references or referrals, and a public disclosure of that may have the effect of disclosing references for jobs that the person referred to never gets, and that the person would want to have confidential unless he or she got the job. And so that requirement might be better to if it tracked the state requirement that if the person, if the gaming establishment receives a reference or referral from a public official, and the person is given a job, that recommendation or referral be reported on a periodic basis. I'm split there on either side, because that doesn't prevent the pressure, but if the pressure is pressure to which someone succumbs, that is, I suppose, more noteworthy than pressure that someone does not succumb to. So maybe the latter would be sufficient. So those are some thoughts that I had. I'd welcome hearing from our consultants as to any thoughts they might have about that as well.
Well, picking up on what you just indicated, Commissioner McHugh, on the notion that someone might want to maintain the confidentiality of a request or reference for employment, I believe that some people were discouraged from applying for the position with the commission and the executive director capacity because it was going to be made public. And they did not want to do that while they were employed elsewhere. I know of instances in the non-gaming area where that's also, a concern. Someone has a position of employment, they don't want their boss to know that they're looking elsewhere.
Yeah, and these would be third-party references rather than applications. So it would not necessarily mean that the person was looking. It would mean that somebody had suggested to the casino or the gaming establishment that they look at this person for the position. But I think the effect might well be the same.
I think it is.
Yeah.
I think that effect is far-reaching,
Right.
and potentially embarrassing,
Right,
to the individual. The other point I wanted to make is I see your recommendation pertains to gaming licensees. Is that intention that if a 100% publicly traded company that owns the applicant, the gaming licensee, does the prohibition go to them as well, the reporting requirement? For example, if someone were to solicit money from Wynn Resorts LLC, which is the 100% owner of the prospective gaming licensee in Massachusetts, would this prohibition extend to them? Or would it be limited to the gaming licensee, which is the way that the Massachusetts has been set up is all of the potential applicants are creating an entity to hold the gaming license, but the money, so to speak, comes from high up in the organizational chain. So I would suggest that the definition might have to be potentially expanded if that was your intent.
46 and 47, I think it is, deal only with the applicant and the prohibitions on the applicant making contributions. And our prior discussions focused only on the applicant, but I think you've raised a point that certainly is worth considering. And I focused on the applicant and,
Right.
and therefore the licensee in this but it seems to me that's a point worth considering.
Right, and it is easy to circumvent this very well-defined reporting requirement by having the parent companies be involved in this activity, and they don't have a reporting requirement. So it would defeat the inherent purpose of the reporting.
Contributions by or suggestions of employment made to anybody who was a investor defined in some way in the applicant.
Qualifying entity, like.
Qualifying entity, the
Right,
company,
qualifier.
yeah, there'd be a way of doing it, for example, and now,
right.
we've been going through scope of licensing, and it in effect would be any entity who is involved in that scope of licensing
Yeah.
determination.
Right. That's a good thought. Thank you. Thank you, Steve. Discussion, thoughts?
You were very much in agreement with the analysis and the thought out process. I believe that yes, the way to ensure public confidence is very effective through disclosure, and at the anticipation of that disclosure, it can effectively elicit the behavior that we're trying to preserve. So I firmly support your recommendation.
I do as well, but I would be interested to know if you're aware of any other jurisdictions who have similar disclosure requirements.
Short answer, no. We are aware, obviously, of some areas where there's clear prohibitions.
Right.
But the answer is no, not of reporting requirements that, as envisioned here.
And do you see it being helpful to our goals, which are to certainly make sure aware of this behavior? Not necessarily that we're not making judgment that it's improper, but just that we're aware and would possibly the transparency may discourage behavior which could be considered improper.
I would characterize it as certainly intriguing. I would suggest that the law of unintended consequences would certainly come into play. We can't envision everything that's likely to happen as a result, but I would point out that in certain areas of experience, we've seen, for example, in New Jersey, an unintended consequence of some of the prohibitions, some of the very restrictive prohibitions against contributions or giving things of value to elected officials it was not originally anticipated that it would be embraced by casino licensees, but it certainly has become embraced by casino licensees because they do use it as a shield. Sorry, I can't help you. I would characterize it as intriguing, the way it's positioned here.
That's an unintended consequence that has pluses and minuses, right?
I'm not sure what the minuses would be, other than to limit arguably, potentially to limit their involvement.
Well, if they were deterred, say, from contributing to the fund to create the new town playground, that would be a negative consequence.
Well, but as anticipated here, if I'm understanding the proposal correctly, that would not, they can certainly affirmatively participate,
Sure.
and they
As
can
long as
certainly
they
still
disclose.
be solicited.
Right.
But
It would have to be
it
disclosed.
would be disclosed and they would know about it.
And all I'm saying is that to the extent they were deterred from making that contribution by the disclosure requirement, that would be a negative consequence of this. On the other hand, contributing to that kind of an activity might well be a positive.
Only if it's perceived as a shakedown
Yeah.
of sorts.
Yeah,
On a practical level, and I think this does anticipate how things operate in the real world,
Right.
is that there is a strong likelihood that there will be a lot of requests,
Right.
in the, whether appropriate or not.
Right.
And I think this does correctly anticipate that.
The other piece of this, thank you, that's very helpful. The other piece of this is that in the current context and environment, this is simply, I shouldn't say simply, this is in many ways synchronous with what's being done on the state level for other things as a result of recent issues that have arisen here, and sort of puts the regulation of this, although it's the regulation of this on a par with, in many places, the way other aspects of the recommendation and request policy are being handled. It keeps us in step with current thinking at the state level.
Yeah.
I asked you, Guy, yesterday to think about it as well, and I'd welcome any thoughts you have in addition to those helpful thoughts from Michael and
Right.
Steve.
I apologize that I had to take a call outside, so I didn't hear the helpful thoughts from Michael and Steve, but I'm sure they were brilliant, as always.
Helpful and brilliant.
And if I repeat anything there, I apologize. But it would seem that there is kind of a mixed bag here. On the one hand, it is a very valid concern, and an attempt to try to address that concern is well worth thinking about, to try to avoid the potential for, as we've said many times today, the failure of trust and confidence in the public in terms of casino operations, so that to enhance that trust and confidence in any way possible. On the other hand, the downside of doing it, it would seem, would be that, as I heard Mike point out, there will be a large number of these kinds of public official referrals. And you will be receiving a lot of information that may or may not be worth looking into. And if at some future point, something that either you were able to look into but not to the depth that you might otherwise, because you'll be doing so many things at once in these initial stages, or you just, weren't able to get to it, you will have in your files information that may later turn out to be something that could be embarrassing, not to the commission, but to other people, and then you'll be asked, well, why didn't you look into this? You had this information all along. That's one potential downside, but obviously you don't want to ignore information that is potentially dangerous or damaging. So I think when we talked about it yesterday, a thought, another suggestion was that there be a provision in the employee license applications, both maybe just the key employee license applications or the regular casino employee applications, that asks whether or not you were recommended for the job by a public official, defining public official as you want. And that way you do get the information. It isn't necessarily, and it will be something that you definitely will be looking at, because it will be in an application that will be referred to an investigator to take a look and examine. And if anything is disclosed as a result of that, you'll be on top of it. And if the public knows that you are adding that as part of your investigatory protocol, that may serve the public interest of them understanding that you're on top of this issue.
If we simply committed ourselves to publication of the referral by a public official of those people who were successful job applicants, it's just out there, it is. And you all can take a look at it, and you, the voters, if you think there's stuff going on, you've got a chance every 2 years to deal with that. If you, the media, want to look into it further, there it is. If we want, in those rare cases, hopefully, that we want to look into it, we've got the information, but it's the same information that's out there, so it's not buried in some file that later embarrasses us because we didn't get a chance to look at it or we overlooked it. Would that serve would just the sort of sunlight shed on this process serve itself a useful process without enormous damage to an important interest, even if we didn't do anything further or except in rare cases, intend to do anything further?
I'm sure there would be a value in the publication of that information. What I can't estimate is whether that value would be outweighed by the countervailing public impression that, there's hundreds of people here who are getting jobs because politicians are recommending them.
Right.
I didn't get a job, but because I didn't know a politician.
Right.
So I don't know which would be the more, which would balance in which side's favor.
Right.
I don't want to, I think they were arguing both sides. Yesterday, we were kind of arguing the issue about public officials not being able to gamble, and we said, well, we shouldn't, there was a discussion of whether we should presume public officials to be honest or dishonest, and in this case, we seem to be presuming them to be different from the way we presumed them on the gambling or not gambling issue.
I'm not sure that I would have been opposed yesterday, if we'd ever gotten to that, to some kind of a requirement that public officials disclose, if they gambled, how much they won or how much they lost, and that be posted someplace so that people could see that, but let them go ahead and do that. But we never got that far.
Right.
So, but I hear you, and that's helpful.
Your recommendation, or at least to put it out there for us to consider this information on an application, doesn't address, though, the donations piece.
I think we already have on individuals. We don't have it on the individual application because we haven't done the individual application yet. But on the BED application, the corporate application, we do have a question about political contributions.
And I think that they will, in all likelihood, be put on the individual employee applications as well. I think the statutory intent, indicates that.
There's no question about that, and in fact, applicants are prohibited until the license process is over from making certain from the time they become an applicant until the time from making certain kinds of contributions, and then thereafter they have to report political contributions. This would be broader than that and deal with, on an ongoing basis, the kinds of contributions in kind, political contributions, and other things that they would have to make. So it would be broader than that, but complement what's there.
Can I just respond to your point, Guy, underscoring an initial point of Commissioner McHugh, which is, in this case, as opposed to the question about public officials gambling yesterday, in this case, the prohibition in many ways, or the laws, if you will, already exist, or the restrictions exist, not by this commission, but by other ethics and other statutes. Disclosure would support the interest, if you will, of those restrictions. In the case of yesterday, we were operating no restriction, and that's.
I see that. You're right. I see that difference.
Okay, good. Thank you very much. Okay, any further thoughts on this one? Well, I would propose then that we take the framework of this recommendation with the thoughts that we have just been given, the helpful thoughts we've just been given, and try to draft a regulation that captures the disclosure of these items, and at the same time considers the drawbacks and the potential pitfalls that we just heard, and then revisit this issue again when we put something to paper that tries to capture these 3 points and along with the pitfalls.
Commissioner, I just want to add one thing on that.
Yes, sir.
We're already in place in Section 108 on the, prohibited political contribution section. There already is a body in terms of the definitions of prohibited person and some of those other
Right.
areas that would be relevant to this.
Right.
In terms of identifying the source of the solicitations and recommendations and stuff. Thought could be given to revising that to expand it beyond, from a title point of view, to include these type of things, and then it would be from a sequential point of view, not a separate section just on disclosure, but would be an additional duty that the applicant or person that would be prohibited in this case would have both a disclosure responsibility, like they have already on political, but a little bit of an expansion in terms of the resumes and things like that. So I just point it out as a suggestion.
No, that's a good suggestion to build on what we've already begun and that dialogue that we've had before that led to that. So let's consider that as a place. Todd, perhaps we could make a note of that and consider that as a place to put whatever else we do in this area so that it all is integrated. Okay. Okay, the next one is number 52. Who has that one?
I do.
Commissioner Stebbins.
Question 52, which was, again, another public submission, was what regulations, criteria, and other requirements should the commission consider to ensure that a preventative approach is taken to work-related injuries and that the casino workplace safety is maximized? I pulled out Section 18. Under Section 18, Gaming Commission must evaluate and issue findings as to the following objectives, including implementing a workforce development plan. Under that subsection 17, implementing a workforce development plan, Roman numeral 4 identifies, asks the applicant to identify workforce training programs offered by the gaming establishment. As you know, obviously, gaming licensees are automatically required to comply with all existing OSHA as well as any specific state regulation when it comes to workplace safety. Our consultants also suggested that we may not have adequate staffing resources to assess and evaluate additional workplace safety plans beyond those already required by law. We all heard testimony from leadership of the UAW and a former casino employee that highlighted the potential workplace injuries that can result from conducting recurring tasks. We should be mindful, I think this was also recommended or suggested by our consultants, that related breaks, other workplace safety measures can sometimes be subject to collective bargaining agreements. I think another outcome of that testimony is that research is ongoing. The study of recurring workplace injuries in the gaming workplace is still being studied to a large extent. I'll jump down. We received one submission on this question from the UAW. Workplace safety can be grouped with several of the questions in the Commission area's preliminary draft, including questions 4, 5, 22, and 25. The workforce development plan or the workforce training programs offered by the gaming establishment is such a broad term that we might recommend that such workforce development plans, which not only include strategies for attracting and retaining employees, allowing them to pursue career pathways within the casino, but to offer strategies and training programs to provide for a safe and injury-free workplace. As you know, in the job description we've used for posting for the Director of Workforce Supplier Development and Diversity Initiatives, we did include a requirement that this position also focus on policy matters related to workplace safety. The Commission, through this position, should remain aware of new workplace safety practices, either required by other jurisdictions or agreed upon between other casino operators and their employees. So kind of following what we've usually turned to with respect to keeping an eye on best practices. my recommendation at the end was the commission should consider requiring an applicant to discuss their workplace safety strategies as part of any requested workforce development plans required in the license application. Again, I think this is an area that, again, we had testimony from an individual who discussed how her recurring motions and tasks contributed to a workplace injury. We don't want to see that for anybody. We know that this is still an area of study and research that producing results that, to an extent, I think Barry is probably still here, and he can correct me if I'm wrong, may not have produced unequivocal or unquestionable results, but I think it's something we ought to be mindful of, and certainly we could request that again, we know that an applicant will be held to OSHA and state safety regulations, but we might suggest that in asking an applicant to submit their workforce development plans, that we ask them to be mindful of what training programs may be related to just maintaining an employee's safety and well-being.
Thoughts?
Yeah, I agree with the recommendation. I would append to it perhaps a little bit, just to make sure that it's not necessarily just at the outset or at the application or at the time of the application, but perhaps similarly to another couple of questions that we discussed yesterday, to require or request from the applicant to submit periodic reports as to, additional procedures that they may implement, towards safety and towards enhancing and minimizing injuries. I would draw a parallel also to the construction industry, to which this question is also relevant. We imply that this is only on the operational side, but indeed most of the risk of workplace injury will come during the construction period. And in large construction projects, the good companies and the good processes really make it a point to continuously report their safety record. Daily, number of days without an injury, and they often, again, the good practices often make it agenda number one in every meeting that they conduct. The discussion about safety, new procedures, etc., because awareness of these issues is at the individual level is often the best preventative measure. There's any kind of posters in construction places that remind that there's family waiting for you, so you ought to be careful, wear your helmet and harness when you're above 6 feet, et cetera, et cetera. So in that spirit, there are measures that we could incentivize by requesting and publishing any kind of reports that have to do with safety measures.
Do others, that we had a presentation by about repetitive motion injury at the gaming tables, which I take it is, as it is elsewhere, a concern. Are there any other states that have some kind of a reporting program or training requirements or ergonomic survey requirements or other things that we ought to be aware of that you are familiar with?
Yeah, not from, there may very well be such requirements, none that I'm aware of that are in place, instituted, or overseen by a gaming regulatory agency, that are left to the existing state and/or federal agencies that already have the expertise in that area.
Right. Yeah, that's interesting. What about that? If we could certainly request hard data of some kind. I'm not sure what we do with it, such as how many workers' comp claims were filed in the last quarter by your employees. For what? We could do information gathering. When we could require in an application specificity of some kind of measures that were going to be taken. But what expertise would we have that would be better than OSHA's or others to police things on an ongoing basis?
I wasn't suggesting that we would have additional or even any expertise that would match that. I was merely suggesting that the reports by themselves would, on the one hand, incentivize people to continuously think about these issues, and perhaps more importantly, report any kind of breakthroughs or new procedures that address things as they appear. I do also share the perhaps Guy's point from before. After a while, requesting a lot of information is going to have a cumulative effect, and we will have a management of data concern.
Right.
But nonetheless, I think the better approach or the better balance would be in trying to be to request information that's relevant, and therein lies the issue,
Right.
for us to publish and make available to others.
I'm not sure it's directly responsive, Commissioner, but something that might be helpful, and perhaps Todd could share with Todd to look at. The National Indian Gaming Commission, which obviously has a general regulatory role over all the Indian gaming in the country, essentially requires a periodic facility inspection. And they had distributed to us a detailed checklist, which contains a whole variety of things. I mean, for example, where do you store your pesticides? Where do you store your paints? Everything that would relate to, relatively detailed employee safety-related things that go beyond, a traditional safety inspection a state inspector might come in. These are pretty detailed things. We could supply a copy to that. You could look at that only from the perspective, or for one of the perspectives being that they require it. We do it annually. Some properties, I think you have to do it a minimum of every 3 years, because now all properties have to be relicensed 3 years. The NIGC doesn't issue a license, but it requires the tribe to issue a license. So when you go for your relicensing, you have to submit this checklist, which shows all of these safety aspects and so forth are complied with. And then it's a self-policing thing, but then it's submitted, and then the NIGC will do a periodic field visit. Either they'll pick portions of it out or whatever else. The net result is, as a general statement, pretty specific stuff. Even going so far, for example, on food inspections, apart from your state inspection system and the other laws that might be applicable, the regulatory agency is required to get, in the case of Indian casinos, the Indian Health Service is usually contracted with to come in for a few days. And they go through and they measure everything from the temperature of your refrigerators. Are you storing chicken, which has a leakage capacity above beef? All of these different things well beyond my skill set, okay, in terms of understanding. But the point being that it ensures that at least there's periodic inspection, and it is in addition to the typical state health inspections and so forth, but it's a regulator required examination so that the licensing can be affected by it. It's not just something that will shut you down for health reasons.
Right.
Your casino license requires you to maintain these standards, and they identify various criteria. So we can get that for you if it would be helpful.
That would be very helpful, I think.
Yeah. That's interesting.
And that exists because this has nothing to do with the sovereign status of Indian gaming?
Oh, no.
So OSHA is already
Applicable under
to-
Indian Gaming Regulatory Act in terms of the general laws that are applicable typically.
I mean, obviously, we also get into, we talked about it before, we have authority with respect to approving the layout of the casino gaming floor. I don't know if that authority would necessarily be boiled down to, again, the case that was presented before us was.
The height of a chair.
The height of a chair. It was, a woman who might have been I would have a different requirement than maybe, you know, somebody who was a little bit shorter than I was. But is it conceivable to think that our authority and regulation over the layout of the work of the gaming floor would extend to that degree of looking at those kind of safety requirements around the floor?
I think the authority's there. I mean, the deferring of that to the experts that do, and there's disciplines, obviously, you know, health, food, and so forth is separate from fire and all this other stuff, but all of those disciplines, when those experts are brought in, I mean, there's no reason why you can't require the applicant, you know, obviously to comply with all the applicable laws, but when an inspection is done like this, the key is not so much that you would have regulations that would reach that level of detail, but that the license could be impacted by the failure to maintain the standards that would be set both by law and then, say, through these inspections. If the inspection produces an adverse report, whether it's, you know, just picking something out of the air, maybe your floors are too slippery, you don't have the proper adhesion for traction, or, I mean, these really technical things. And enough people get hurt, and that's documented in the course of an inspection when the inspector says, how many injuries have been sustained in this particular hallway? That's a real detailed thing, but that, an applicant can be put to that test and be required so that the health and safety of the patrons and employees, not just the employees, are met. When we were first presented with this only came online, although we've had a compact requirement in one state for 2 decades. The federal inspection has only really taken hold, I think, about 3 years ago, where they required this. And the first time we read it, we said, oh my gosh, this is pretty onerous. But then when we did it, you know what, we found it very practical. And it gave us a good opportunity to go through and look at these things and make sure that they were being met, and holding the managers, you know, the people that are there, to the responsibility of enforcing this. And we found it useful. And again, it'd be something we'll submit, you can look at it. It contains essentially references to the disciplines but doesn't go into each and every detail. But it's a heck of a lot detailed than a check that says fire inspection, food safety. You know, it has enough steps in it. And like I said, you know, it's things that I wouldn't certainly think of. When you do your pesticides, where do your pesticides run off to?
Right.
Okay, do they run off to hard surface or soft surface? Are they absorbed? You know, things are areas, you know, restroom safety, a lot of different things. But the kind of thing that it will give you criteria at least to look at, and then you could examine it closer to see if you wanted to put some additional levels of compliance from a regulatory point of view.
And all tribal casinos are
have to abide by that when they do their relicensing.
It's almost an accreditation process.
Yeah, in a way.
Yeah.
Safety accreditation to speak of, yeah.
That'd be very helpful.
Yeah, one other point is that it's
Really
not,
helpful. Thank you.
it's not unusual, nor is it necessarily undesirable for agencies that oversee health and safety issues elsewhere to come up with very specific rules and regulations that are focused on the unique characteristics of casinos. I mean, the best example is that, I don't know if it's still in place, but I believe it is, that there's, in some jurisdictions, there's a requirement that a slot machine not be greater than 6 feet tall unless it's against the wall. And the reasoning being that it interferes with sight lines for exits and so forth. That's not a gaming regulatory requirement. Indeed, no gaming regulator I know has the ability to properly assess that. It's another agency that puts that requirement. They created that specifically for casinos. And casinos, the only role that the gaming regulators have is that is checking off that casino licensee has complied with those requirements.
You know, it may help us to kind of extend this conversation to have conversations with existing federal and state agencies in terms of, obviously, they're again, the issue presented before us was with injuries from recurring tasks, recurring motions. You know, going to those experts, I mean, going to the people that are already regulating that, probably on the, you know, manufacturing floor or wherever, and just see how they regulate and administer it, and what guidelines they might have.
Well, thank you. We would welcome seeing the NIGC checklist. And why don't we consider for this one, at a minimum, requiring an applicant to discuss their workplace safety strategies as part of any requested workforce development plans that we require. And then explore A with other agencies, federal and state, and after checking the NIGC list, any other requirements we choose to promulgate that deal with the general subject of workplace safety, either directly or by monitoring the activities of other licensing, other regulatory bodies. Does that make sense? Okay, the next one is, and the penultimate one is number 53. Should the commission consider a rule or policy that prohibits public entities from either becoming applicants or financing applicants? And I take it that this is for a gaming license, right? Or for any license?
That's the way I read it, is for a gaming license.
Okay.
Again, I looked at relevant sections being the definition of a, I looked at the definition of a institutional investor. Though the definition, obviously, of public entity can be defined broadly under Section 2, there's a definition of an institutional investor for a gaming license that the license applicant that includes any of the following entities having 5% or greater ownership interest in a gaming establishment, a gaming licensee, a corporation, bank, insurance company, et cetera. The language clearly allows a public pension fund the opportunity to be an institutional investor for a gaming license applicant. Obviously, we've moved past the RFA 1 application period, which closed on January 15th. I don't believe any public entity submitted an application or was potentially part of or is a qualifier in an application. It would not be obviously fair for the to allow fair competition for the MGC to consider allowing a public entity, again, beyond those public pension funds, to participate in the applicant in a future license application process. Presumably, the MGC required application fee investment requirement would most likely also be prohibitive to a public entity seeking to become an applicant. The statute, interestingly enough, already does prohibit a casino licensee from being an applicant for the state and local tax incentives under the Massachusetts Economic Development Incentive Program. That's outlined in the statute, which could be viewed as a program that would be financing an applicant. The program, at least on the local level, allows waiving of local property taxes. Again, I think John Samba mentioned in one of his policy questions yesterday, tax increment financing is a way to help sustain a development project. There was a second part of this question. Under what conditions, if any, could a public entity be the beneficiary of gaming revenues or profits? Again, this was kind of an interesting question. I'm not sure I'm defining it correctly, but public entities, including hosts or surrounding communities, public entities, and public utility entities, potentially will, in essence, be the beneficiary of gaming revenues and profits through any funding provisions of the host surrounding community agreements and or utility service agreements. Additionally, gaming revenues profits will also be used by the licensee to pay all required tax or assessment obligations to the host community and the Commonwealth. The statute also clearly defines the funds and allocations of the tax receipts. So I would think that would answer the question of when a public entity becomes the beneficiary of gaming revenues or profits. We didn't receive any written submissions on this question. And my recommendation is we take no action to draft the regulations with respect to this question at this time.
This is unlikely to arise at this point, so far as we can consider the landscape, at least for 15 years, and then it'll be somebody else's issue.
Did we kick the can?
But I welcome any other comments. All right, let's accept that.
Just one thing. I think this arose, this question, out of it's moot now, I would think,
Right.
but the concern of fairness in a competitive application process, if one of the applicants is the school board and another applicant are just a bunch of private entities, would the commission be more inclined to give more of credit to a public entity that would be receiving the benefits of a casino rather than all private entities? But as the commissioner says, this is, all the applications are in and no school boards are included, so it's moot.
Thank you.
Okay.
Now, does that conclude, I have number 34, which we haven't touched on. Was that meant to be number 33, Janice, or 33 and?
33 and 34.
33 and 34, there it is.
Yep.
And that was, who has that one?
I-
Bruce?
Right.
Lucky me, I have that one again. Key policy question 33 asks whether the community college process that we're endorsing and supporting be the exclusive mechanism for qualifying applicants for key gaming licenses. I think through a handful of public meetings that we held that we decided that would not be, that they would not have an exclusive arrangement, and that was not alluded to in the MOU that we signed with the Casino Career Institute / the community colleges. If the answer to question 33 is no, which it is, should the commission regulate private training schools? And again, I allude to section 5, 11, and 12, where we shall establish licensure and work permits for employees, as well as minimum training requirements, and may establish certification procedures for any training schools. Again, regulation of private and public casino gaming training schools varies by jurisdiction. Pennsylvania and Indiana do regulate public and private training schools, and I've provided some background on what Pennsylvania does as well as Indiana. At this time, I would suggest the MGC, and we have been, continue to work with the Division of Public Licensure. DPL is authorized to license qualified private occupational schools and sales representatives, lucky enough. Adopt rules and regulations governing the licensure and operation of private occupational schools, approve curriculum, instructors, and staff. Through our discussions with the Casino Career Institute, we've discussed steps that the commission should consider to help protect residents from training schools that could potentially harm the consumer. In the meantime, MGC and DPL agreed upon the following language to be included in a DPL licensure approval for any gaming training school applications. That first disclaimer being is follows: the courses offered by this school may not satisfy requirements yet to be established by the MGC for employment in a Massachusetts casino. Second provision being employment at a Massachusetts gaming establishment is not available at this time. It is not known when such jobs will be available. When gaming employment becomes available, a Massachusetts graduate school may need to meet additional requirements set forth by the MGC, i.e., EGB at least 21 years of age, criminal background check, drug test, et cetera, et cetera. We received one written submission on this question from Shefsky and Freilich on behalf of the city of Springfield. Their comment was, no, we do not believe that the MGC should regulate such private or other public training schools, as we believe the market will determine whether graduates from such schools are appropriately qualified. My recommendation is the MGC should adopt similar training school approval regulations and minimum training requirements as we're allowed by statute in cooperation with DPL, and obviously any regulations we propose would also be available for public comment.
Well, this ties back into the discussion that we had a little while ago, and I think the consensus was, if I can accurately summarize it from then, that we should have, this was in connection with the licensing discussion, that we should have some mechanism for certifying training schools, that DPL is the licensing authority, but the sort of Gaming Commission stamp of approval is something that we can have a role in doing, that we do. That we can set licensing requirements that capitalize on that certified training, and that we can think about enforcing the competency requirements through alliance with and imposing requirements on the casinos to create a list of qualities that they're looking for, and then enforce that through spot checks and other things. I don't know if I've summarized that correctly, but would that be consistent with your recommendation, or would you think that we, Commissioner, ought to have a more active role in the training and the curriculum setting and the curriculum ensuring requirements?
Again, in looking what our Casino Career Institute is recommended is minimum training requirements that I think would adequately or are accurately and equally reflected in basic training school requirements in other jurisdictions. So I think it's fair to say it's simple enough to establish that bare level of training, obviously with input and suggestions from our potential applicants who are going to hire these individuals. But no, I think to your point, we're on the same page. I think previously we came up with the language relative to disclaimers for DPL because they were sitting with a pending application from a training school that wanted to open. I think that was just kind of our first effort to try to, again, make sure that no harm came to the consumer. But I would like to think, we have some additional time to work on this with DPL. Again, allow their footprint or responsibilities not to be stepped on. But again, I think this is an opportunity for us to add in, again, some basic minimum training requirements as we're required to do, and have that be reflective in their process.
I can enlighten this a little bit. From 1978 to about 1993, New Jersey had actually a license category for training schools, and required dealers and related personnel to have been certified by such a licensed entity. That ended. The rationale behind it was that if a jurisdiction does not have adequately trained dealers, it's going to be a magnet for cheats and so forth, and the state government has an interest in, gets a share of that, so therefore it has an interest in it. That ended in '93. The license requirement went away. The oversight of the schools went away. The new rationale was that while the state has an interest, the casino has an overwhelmingly larger interest in making sure that games are run properly. And the rationale was that if you want to encourage investment in this industry, let them operate as businesses. That was essentially the rationale. So you had about 15 years of experience with schools, and I guess about 19 years since. And the only visible outcome I could see from that change was that the schools, and I think maybe it was 3 of them, went out of business. The casinos themselves took over the business of auditioning and training their own dealers, and in the various games were able to do it to better meet the demands in the particular games and so forth. There have been no, to my knowledge, visible issues with respect to increased amounts of cheating. Now, that But bear in mind, another factor that went into play is that they also reduced some of the oversight requirements in terms of supervision. So if there is more cheating, we probably wouldn't know about it. But that was, the rationale changed completely from 78 to 93.
And what about other jurisdictions other than New Jersey?
I think that summarized pretty well here. There's the ones that are cited here, Pennsylvania and.
They do regulate.
Yeah, I'm not sure I don't know if they license the schools and what the requirements are. I could certainly get some more detail on that if you're interested, but.
Well, the schools have to be licensed under state law here. So, I mean, they just can't start up a school. They have to be licensed. And there are certain basic licensing requirements applicable to all schools. And so they have to put the money in a safe place, and they have to make sure they're giving some training and stuff. But we certainly can, as we discussed with the DPL, we can certainly create and then have them enforce the requirements they need to receive an MGC certification as an approved training school. I mean, we could do that without taking on a huge administrative burden, I think. And then the question would become how to ensure an ongoing competency, both from the time the person graduated from the training school and as he or she proceeded through the ranks. And there we might be able to capitalize, as we talked earlier, on the employee handbooks and the expertise of the casino.
I think there's also a little extra caution here because, as you pointed out, the schools in New Jersey were kind of through that ramp-up period as you introduced gaming in New Jersey, where you had potentially a huge rush of people trying to fill these jobs, find a way to get trained. And obviously, at some point, as the industry matured and the work, you find a way to kind of understand, you're a person I want to hire and you can go through my specific program. Again, maybe that's why, New Jersey put those precautions.
Well, there's clearly going to be a difference here in that it's obviously in a competitive bidding process where training and how they train, how robust their training programs are, and how early they start is going to be obviously part of the review process. Right. So you can certainly anticipate that applicants will be working either with community colleges or developing their own training programs, but are not going to ignore this issue. And I think that was not present in New Jersey at the time.
Yeah, I would underscore that we go back to the workforce development plan that will be part of that application, and this initial, bulk of demand for a number of positions that under a different or separate, if you will, goal of their legislation that jobs go to people who need them here, which was another worthy goal. So,
well, it seems. Thank you very much, Michael. It seems to me we've coalesced around the notion that we should adopt not sort of certification requirements for training schools. We should promulgate those, and then beyond that, think about the best way to ensure continuing competencies, whether we do it by an independent set of regulations or by drafting a set of regulations that piggybacks on gaming establishments' own training requirements, and making sure that that we approve those requirements and that they follow.
right.
Does that capture the spirit of where we are?
I think it does well.
Okay. All right, anything further then? I think that's the last one that we had on the agenda, and the last agenda for this week, except for tomorrow's. So I then would, with gratitude to our consultants for their insights and their help and assistance, accept the motion to adjourn.
So
All in favor?
Aye.
Aye.
It's unanimous.